indicated also.
Very well.
Monday I'll allow mentioning.
Very well. Very well. So, my lord, let the matter be listed on Monday. We'll come back. Otherwise, because I'll tell you, Lordship, my lord, there's a time frame.
Very well. List on monthly list. Monthly list.
Monthly list.
Has to be listed in the monthly list. Thereafter. That's the usual practice, Mr. Bose. Otherwise, I do not entertain any other matters.
Very
Yes, call the list.
good.
Sorry, madam, no urgency in section 24, madam. What are you saying? Yes, call the list. I've indicated there is no mentioning today. Please understand, madam. On Monday you mentioned. You mentioned it on Monday.
In the Bose's matter, my lord, in the Bose's matter, my lord, the only difficulty is this: if it is appear on Monday, my lord, let it be on to be mentioned or on the top, my lord.
Let it appear. We shall see, sir. Let it appear as motion. Yes, call the list. Yes, item number 1.
Yes, my lord, I am appearing on behalf of the petitioner and my lord,
Opposite party husband, lordship.
Yes.
my lord, on the last occasion, your lordship was asked my learned friend to calculate the amount due to the wife, my lord.
File the
23rd. Order dated, my lord, 23rd December. My lord. Since last 2023 to till date, my
This is a
lord,
transfer application, lordship.
whatever may be, my lord.
Yes. Who is the opposite party?
I'm the opposite.
Where is the check?
Lordship, I have not been able to communicate with the client, lordship. Kindly grants me some time, lordship, because lordship.
You could not communicate with the
Lordship.
client.
Lordship, this is a transfer application, lordship. Yes.
You could not communicate with the client.
Lordship, I could not, lordship. I have been able to just give the consent letter on the last date, lordship. Thereafter, I have not been able.
I've recorded the order. You have seen the order.
Lordship, I've seen the order, lordship. I have
So,
not been able to communicate.
no order for transfer will be allowed.
Lordship, he has paid
Proceedings
for
will
transfer.
remain permanently stayed and you will be paying alimony.
Lordship, he has paid for
In
transfer.
this, naturally, sir, nothing will happen. You will go on paying. And I will ensure you pay this. So what is this happening?
Lordship,
You don't bother to adhere to directions passed by a court of law.
lordship, kindly
You
appreciate, lordship.
think that
He
your
has
client
filed
can take advantage of the situation, sir?
No, lordship, I'm not trying to do that, lordship.
Where is the payment? I have directed you to place before this court a check.
I have not, lordship, I have
Let
not.
him be present on the next occasion. Since it is
In compliance with
yes, sir. Please remember that you have to produce the check for the entire outstanding dues.
in compliance with my lord's order dated 10th of December, my lord,
Yes.
an amount had been paid and the rest of the amount, my lord, I am handing over by way of a demand draft, my lord.
Just a
There
minute.
was also a direction for Lordship kindly takes my 23rd December order, my lord.
Yes. Where is your affidavit of asset?
My lord, I have made the demand draft. The affidavit
Where is your affidavit of asset?
filed, not my lord, filed. it has not been filed.
Why?
My lord, the reason being, my lord, your lordship had recorded on 23rd of December.
Yes.
Since the order dated 10 December has
Naturally, now the order has been passed.
not, the demand draft is ready. my lord.
Demand draft, you hand over you whatever you want to do. Where is your affidavit of asset, sir?
It could not be made, but the entire amount is by way of demand draft, my lord. 1,29,000 was deposited before the trial court, and this is 5,07,000. The balance amount out of 6,36,000. The entire payment is here, my lord. এটা কত can file করুন?
So how much, what is the figure?
5,07,000.
And on the last occasion, how much did you pay?
I had paid before the trial
1 lakh.
1,29,000.
Where is that figure?
1 lakh
From where do I get it?
yes, my
I
lord.
had directed you to produce a check amounting 6,36,000.
Yes, my lord, but since it was
No, I do not know.
deposited, my lord,
Where is the entire amount?
my lord, they have
There is a direction passed by this court. Explanation will come later.
let me show, my lord, the order of the trial court.
Yeah,
my
no,
lord.
no, order of this court, sir. Sir, order of
Yes,
this
my
court,
lord,
sir.
but it has-
10 December, sir. 10 December
Yes.
order, sir.
Yes, my lord, after 10 December, the learned advocate of the respondent husband, my lord, had deposited 1 lakh 20
Why?
before the trial.
Why?
My lord,
Why?
arrange-
Despite direction passed by this court to produce it, he goes before the trial court and makes payment there.
he could not arrange for funds.
No, he
But-
goes and make. Sir, what do you, does your client consider himself?
No, my lord, he could
No,
not
no, he
arrange-
considers himself above the court. He can take the
Certainly
court for a ride.
That is the reason, my lord, to comply with the order.
No, no, you
the-
pay, you make the entire payment. Sorry, sir. Whatever you have paid there. I want the entire payment in terms of the direction passed by this court to be placed here.
my lord,
Who
that-
asked you to make the payment before the trial court?
my lord, that was the amount he could arrange.
No, no, who asked you to make the IT? There was a direction to make payment before the trial court.
No, certainly not,
Then-
my lord, but perhaps.
Sir,
he
where
was
is your
paying-
client?
my lord,
Where is he working? Where is he working?
he's making the gate pass, he is physically.
No, no, where is he working? Tell me. What is he doing?
My lord, he was earlier working in Cognizant.
Now, where is he working?
At the present moment, my lord, he is at a loss of pay, my lord.
Where is he working?
My lord, he was working in.
Now,
Cognizant.
where is he working?
My lord, your lordship may kindly make it pass over. He is coming.
No, no, you tell me where is he working. I don't want to hear. I will not make it pass over. This court is not going to wait for him. His antics, despite direction passed by this court on 10th December. No, in that case, I'll pass appropriate
My
orders.
lord, the check could have.
You have
gone,
not
but
complied with the direction passed by this
but
court.
This is by way of a demand draft, my
You have not complied with the direction passed by this court, either on 10th or on 23rd. Where is your affidavit of asset?
My lord, that
Nothing.
could not.
Where is your affidavit of asset?
Taken out an application, my lord, kindly, my lord, hears me out, my lord.
I will not. I'm not going to hear anything unless he discloses his affidavit of asset. I will not accept the demand draft also. Let it be remain with you. I will ensure if he considers he can play with the court in this fashion. On 10th there was an order.
Yes.
He goes before the trial. What was the order? What? Read the order.
my
Place
lord,
the order.
is of,
Read the operative portion of the order.
my lord, having regard to let the matter stand adjourned and be listed as to be mentioned on the returnable day, the opposite party is directed to produce a check amounting to 6,36,000.
Did he comply with this direction?
He could not,
No, he could not. Instead, what did he do?
my lord, he paid.
He went before the trial court, deposited 1,36,000 according to you. Who asked him to deposit that?
My lord, he was taking instructions, my lord.
Who, from whom?
My lord,
Who is giving him instruction? Contrary to directions passed by this court, I want to know. Is any advocate giving him instruction to do this?
my lord,
Then let the name of the advocate surface. Let us understand the situation.
my lord, your lord.
This is a direct interference with the judicial order, sir.
But thereafter, my lord, in compliance with that, my lord, the entire amount.
No, not the entire amount. It is only how much?
5,07,000 because they had already received 1,29,000, my lord. They have received.
Who, how do I know?
My lord, there is an order of the trial court.
Why did you go and make that payment there? There was a direction passed by this court.
Certainly, my lord. But at the same time, it was received by the wife. The petitioner wife have received it. My lord, it is
Did you
recorded.
receive that amount?
मतलब 1,29,000 मतलब probably मतलब he has paid
No,
to the
this-
direct to the bank account मतलब to in order to मतलब and he has taken that मतलब benefit and gone to the trial court and said, see, I have already paid.
Show me that
and-
amount. How
and
did you
order
pay
to-
this?
My lord,
Trial court has
this
not
is
done.
the order of the trial.
Nah,
court.
sir, I can deal with
Not
such people, sir.
My
Who
lordship,
consider,
kindly
sir,
see what
that
is-
the orders passed by this court need not be adhered to.
My lord, he could not arrange for the funds. That is.
Sir,
the
this
reason.
does not appear from this. His conduct.
On the previous occasion on 20th.
Where is his affidavit of asset? He could not arrange his affidavit of asset. Are you trying to suggest?
On 23rd of December. When
Very
the
well.
matter-
Show me that demand draft.
This is the order of the
This is
court,
the-
what he has done before the trial court. My lordship will kindly see that. And मतलब again a violation of your lordship's order. Well, he has not filed an affidavit and probably he has filed an application showing that he is an unemployed.
আমার বলতে দাও, it is actually-
Well, how can he मतलब affirm such?
My lord, let me indicate, my lord, two things.
Have you received this amount?
1,29,000 as per my instruction he has received in her account. And we have given a immediate mail. Mail ta.
Demand draft টা দিয়ে দিন।
Yes. These two mails immediately we have complied. We have communicated to the husband, madam.
ঠিক আছে?
Mail করেছি তো কি কপি
আরে
দেবো?
আমার কাছে নেই।
Although by considers himself smart, this smart, that he can dodge court's order, will not comply with the order, make payment before the trial court. Sir, it is unfortunate to say the least. I don't know from where he is getting these instructions.
But nonetheless, my lord, it will be complied with. I
Yes.
assure your lordship. But at the same time, my lord, let the parties settle the dispute because it's out of a matter.
that will
আচ্ছা ওই লাস্টে এটা দিতে হবে না, তোর ভিসা আটকে যাবে, ইনজাংশনটা লাগবে না। Let him come on 7th. If he does not come, please remember.
He will be there. He will be
Yes,
there.
with the affidavit of
But he will
assets.
be, personally.
Yes, call the next matter.
Yes, Sumana.
I don't want to see him personally. I want to see the affidavit assets.
I'm grateful.
7.
On 9 December 2024.
This matter? Don't mention. No. Yes.
Lord on.
7 তারিখ 7 তারিখ। হ্যাঁ। Oh, there is one more correction on the order date. Let the order date, take it. Appear in the list you mentioned.
No, month list of February.
April.
Lord,
I'll try to take up the monthly list. That's why I'm trying to pace it out.
that's very good. Wait. 4 and 5.
Yes, Mr. Right?
Lord, my father.
Very sad to hear. Very sad. When it happened?
Lord, 15th of December.
15th of He was suffering.
Lord, he was.
My condolences.
Your Lordship, Mr. Shorodipto Banerjee is appearing in this matter. I've been instructed by him to seek for time
Extension of interim order.
since he's out of station.
Extension of interim order. You are there. Yes.
Lord, the orders, Lord, which have been impugned in these revisional applications, Lord, one of them is, Lord, allowing amendment, Lord, without, Lord, taking into consideration a written objection, Lord, was not even allowed to be filed. Second, my Lord, is the order whereby, my Lord, the amended plaint was filed much beyond the time, my Lord, within which it was supposed to be filed in terms of the directions passed by the learned court. My Lord, written objection filed by us, my Lord, was also not taken into consideration there. And my Lord, interestingly, prior to the filing of the amended plaint, my Lord, we had already filed, my Lord, our written
The
statement.
interim order was subsisting.
Yes, my Lord,
but
it
was-
expired in the meantime, my Lord, because of the vacations, my Lord. And we had filed therefore, my Lord, an application.
Your
for
application was filed
reimposition.
when?
My Lord, after the reopening.
After.
Lord, it's for reimposition, Lord, and
Very good. I'm extending the interim order. Come back thereafter. I'll please. Having heard the learned advocates appearing for the respective parties. Now, this is an application interior playing. Contested application. Contested. Aget contested. Under the heading contested application.
My lord, I am for the petitioner. I am for the respondent, my lord. The petitioner before your lordship is the defendant and co-owner of the property. The partition suit. My lord may come to page number 41. Against the it is come under a heading, but it is a minor, very little matter. Small matter. That is why your lordship posted it matter for hearing. I have filed one application for amendment only to incorporate 42 square feet of land in the partition suit schedule because the deed in which our mother has purchased 142 square feet land of the property which discovers latter. At the time of filing the plaint as well as the written statement, it was not within the knowledge. My lord may come to,
This is your petition.
no, this is my petition, I am plain,
It was disallowed.
no,
Your amendment application was disallowed.
no, disallowed, my lord.
Where is that order?
My lord may come to.
On what ground was it disallowed?
16/4/2014. Today is fixed for the hearing dated such and such. Both the parties file hajira. This case is taken up for hearing, heard both the side. Dependent had filed a written statement on Ato, petition dated Ato. In written objection, and all other petitions are rejected for sake of the trial of the suit. All the prayers which are passed of such petition are to be agitated at the time of trial.
How? Yes, sir. You tell me how.
My lord, it is fact that trial has not.
No,
been
you
covered.
tell me. Forget trial. Forget trial had comments or not comments. You tell me how it can be agitated in the trial.
It was, no, my lord.
How can a fact
My lord.
which is not pleaded be agitated during the trial? Tell me this first.
My lord, this
Sir,
amendment has to be allowed. I agree. my lord.
Then,
Only one humble submission.
yes, tell
Only one
me.
humble submission. Kindly appreciate this. Written statement was filed in 2018.
Partition suits are at the end of the day.
Yes, my lord.
Had it been any other suit, I would have awarded cost.
No, absolutely, my lord. And this amendment was filed in 2022. Kindly see the amendment application. No reasoning, nothing, my lord.
Bad, they are bad people. Hurry, sir, at the end of the day,
Absolutely,
you
my
are
lord.
suffering.
Absolutely.
Let me allow it.
With cost, my lord. My humble
What cost will you take?
for the delay, my lord. For the delay. 2018 to 22. And kindly appreciate the page 41, my
If
lord.
it's a genuine, you see, let me see the application.
Page 40, running page 41.
41, my lord.
No reasoning, no, why it was delayed, my lord, nothing.
Brilliant application, sir, I must say.
My lord, what I am telling, my lord, it is a landed
the
portion of
It's all
the.
right. Come to the petition, sir.
Actually,
village was
the
came, my
landed
lord,
code below
nothing.
petition, these types of.
Not necessary to write even on one ground, one particular
My
ground.
lord, if this petitioner is not allowed, nobody can avail the.
I am not. We are not on that. He is not on that. What
I
is he
have to
saying?
Your lordship, I intend to, I am
There is no
pressing
point
this
in permitting
application.
you to
I am
file a
pressing-
fresh petition or a supplementary affidavit at this stage. No point.
Well,
Is-
even they didn't file any objection there too.
Yeah, but no, you have filed objection. You did not.
I could not get any scope, my lord, because this trial
On
code
the
is very
first
fast.
And a
day,
trial court
on the
said that
first
this
day
has to be
it is-
agitated during the trial.
My lord, this trial code is very fast. So I could not get an opportunity. To,
My lord,
honestly. So
very fast, very fast. 12 judge is very fast. My lord. Even the stay
I could be
petition
very
was
confident
rejected.
that this amendment has to be allowed. True. but
Only give the mercy. You bring the order. I want to know the order.
Any reason, my lord, in the application, my
My lord, kindly excuse me the cost, my lord. Kindly.
my
And
humble
the
submission, my lord.
expedience, the trial for, and they give one direction to
I-
finish
Where have
the.
you stated what you submitted now? Where have you stated in the present petition? In the present petition.
It would have been.
No. In the revisional application, you must have stated this. That is not stated in the revisional application as well. Everything is oral. No, sir. Then I cannot help.
My lord, kindly have it.
Then I cannot. Then you have to file a supplementary affidavit. At least clarify the position. Why are you seeking? Everything cannot be oral, sir.
My lord,
Everything cannot be. Come tomorrow with the supplementary affidavit.
well, tomorrow cannot be.
Why? One page. Just whatever you have submitted. If you have not even indicated that in the
My lord may come to, my lord.
any paragraph is there.
Yes,
Any one paragraph will do.
the application amendment, my lord, 6. The written statement to the learned advocate of the opposite party petitioner, in spite of due service of the copy, the application to the petitioner, no written objection was filed.
Forget all
petitioner
that. Why
defendant
was it necessary to
submits
amend?
that delay attributed by the defendant petitioner at the
Out of the
time of
knowledge.
Arey, forget
submitting.
it. Where is your statement that
My
this
lord,
is
this is my lord.
where is that? Where?
4 lines from the top, my lord, paragraph number 6. The petitioner defendant submitted that the delay attributed by the defendant petitioner at the time of submitting the written statement due to non-availability of the certified copy of the said annexed document, annexed document. The defendant did not have official knowledge about the said document, and the same has been located recently, and on being found the same, the necessary certified copy of the said procured, and thus the situation prevented him to disclose the defendant.
In trial court, my lord.
Well,
Certified copy was not also annexed, my lord.
Certificate copy is here. Now certificate copy is available.
Statement, my lord.
here is.
No, you disclose it by a supplementary waiver, next fixed in position. I will allow you.
Monday,
Monday. No, not Monday. Monday monthly list is there.
Tuesday.
Yes, Thursday, next Thursday.
They started stating the
Same position, same position.
Stating
On the
the
prayer of the
matter-
learned advocate for the petitioner, let
no,
call upon you to disclose
no.
it. Adversarial proceedings, if you do not disclose, you suffer.
Well, everybody is the landing of the staircase. If it is not allowed, my lord, he cannot.
You bring it. Why am I
I
making
cannot fly.
unnecessary arguments today? Yes, call the next matter. Daku. Petitioner also only appear
The
করছেন
petitioner in
petitioner.
this matter.
হ্যাঁ, same position এ থাকবে কোনো. Yes,
And for the petitioner in this matter, your lordship remembers this matter, my lord, the application,
correct, yes, fair portion.
interim order, now it has been
Because
corrected.
he's appearing on behalf of the opposite party. He's on legs, your lordship. Kindly
Right,
take it
right.
up.
Why he'll oppose?
That's all.
What will he oppose?
Madam, the interim order has already expired, your lordship.
Reimposition they are asking.
Your lordship, the present learned court is also not there. It's a short matter. If my lord hears it out,
What is the matter?
Order 7, Rule 11, filed by them, has been rejected, your lordship. I am the plaintiff.
Yes.
I am suffering the stay, your lordship.
That's a plaintiff, okay.
I'll hear it out.
Sir, kindly
The,
takes it up.
Not now.
suit has been stayed, not the order. She's enjoying an order of status quo against my property
Rejection on what ground?
on grounds, but several grounds. One of them
One-
being the right of preemption is there, non-disclosure is there, several suit is pending. Subsequent
Let
purchaser.
me
Kindly extend the interim order.
mention
and then,
Mention it.
Kindly fix it up on Monday.
if
And
required,
because,
fixes it. I have no problem. Let the matter be ordered. Interim order be
The
extended.
present is also not there, your
No,
lordship.
but
That
let
is
the
upon
interim order.
instruction I
I did not say anything one day before
Having
the
heard the
vacation.
learned advocates appearing
Date.
I'll fix a date.
Fixing a
No, no,
date,
no,
Lord,
it will be
it
taken
means
up.
nothing,
No,
Lord.
it will be taken up.
Either it comes up or it doesn't come up on
No,
that.
it will be taken up.
But depending upon my lord's determination being there. But I was
That I
requesting your
don't know.
lordship,
So
Lord,
that is the reason why.
the interim order, let it be not up.
No, no,
not
no.
End of
That's-
February.
Initially it was till November also.
Yes.
Initially also still now. You did not take out any vacating application.
Sir, in civil revision, I tell your lordship,
And-
Lord, I heard my learned friend saying that I have not taken out an opposition, I have not taken out a
No, vacating application you could
But
have.
as of now, Lord, so far in my practice, Lord, as we know,
Yes.
there's no concept of a opposition taking out. Lord, as
Opposition
a-
is not necessary. Opposition is
Not
not
a vacating
necessary.
application.
No, if you want to be vacated, you can
Petitions
take
are
out a
not
vacating
taken up,
application.
Lord, generally, even at the extension stage and disposed of.
Let us see.
But
Let us see.
because
On
the-
21st, Mr.
It is my suit. Lord, that is the
Mr.
reason. Lord,
Mukherjee,
I'm
on
prejudiced.
21st, I fixed it in the list.
I
21st.
understand that, Lord, but kindly, Lord, prepone the date for extension, Lord, that.
No, no,
interim order
extension,
that
let
is
it remain. If it is
half the
disposed
year
of,
gone.
disposed of. I think it will be
And if
disposed
it is
of.
not taken up, Lord, then I'll be prejudiced.
If it is not
Let-
taken up on 21st,
Meant
you
liberty to
mention on
mention.
21st itself.
Yes.
If it is not taken up, it will be marked in the list 21st
Very well.
with a date.
No, let
With
it
a
come on,
date.
let it come on, Lord, February. I was, Lord, beseeching your
So
lordship.
with that
after
date will
you,
come.
Lord, that
Not
interim order,
February.
Lord, that is not.
I can do this. Then I'll mark it in February without the date. That will not help you.
But I was
Choice
not
is
on-
yours.
Not on, Lord, the date of returnable date. I am on, Lord, the extension of the interim order. till, Lord,
Usually,
June.
Mr. Banerjee, no, returnable date, whenever it is, it will be coming and on that date will be taking over. It is on a fixed date.
But let it be at the end of, Lord, February, or at least not the end of March.
No. I usually don't do this.
But
Let it
then
be.
I have to come and again bother your lordship with.
No,
an
not necessarily. On
application for
February 21st, February, a date
It
has
will
been
come.
given in your matter.
But I will come back on, Lord, 21st.
Yes.
Let us see, Lord, how it-
ওটা হচ্ছে রিটার্নেবল মোশনে দেবে আন্ডার দি হেডিং রিটার্নেবল মোশন নট কন্টেস্টেড
I'm grateful.
My lord, in item number 8, Mr. Shokabdar is appearing on behalf of the petitioner, but he is engaged in courtroom number 38. I'm praying for a short passover, my lord.
Appearing before for respondent number 1 and 2, mine.
What is the matter? Extension of interim?
Extension of interim order, my lord, my interim.
Are you aware if it is not extended today, what will happen?
My lord,
You're not pressing for extension.
then my lord, may extend my interim order. My interim order already expired on November 2024, my lord.
November?
2024. I have filed an application also, my lord.
Yes. What is the matter, sir? What is the matter?
My lord, I'm not briefed in this matter.
You must be aware, sir. What is the matter, sir?
Regarding this matter, my lord, on 18/4/2024, an ex parte order has been passed. And for because they have not filed the WS. And on the next order, on 8/7, the WS has been allowed. Challenging that order, they have came before the honorable court. The respondent has already filed an application. I will file my opposition, my lord. So kindly allow me to file my opposition. I have no objection if they.
To what opposition you will file? Yes, madam. Yes, WS has been accepted. What is the difficulty?
My lord will kindly extend the interim order and.
No, I will not.
My lord.
I will regularize that.
Yes, my lord.
I will regularize that. Pay cost. How much cost you are willing to pay? What is the suit for?
Declaration.
Only declaration.
Just a minute.
My declaration and injunction, my lord.
Declaration and injunction also.
In respect of suit property,
In respect of the suit property.
valuation is
They
when was the suit filed?
My lord, the suit was filed on 2023, my lord.
And when did you file WS?
WS was filed, my lord.
Within 5 months, madam.
Yes, madam.
There is a limit to everything, madam. 5 months the WS was filed delayed, and you have successfully delayed the rest of the hearing of the suit. From July 2024, we are still going on. I'll dispose it of. 5,000 rupees pay cost. I think.
will kindly consider 2 mile or
No. Nothing. These matters unnecessarily. He'll pay cost of 5,000 rupees. I'll regularize everything. And he go and contest the suit.
Fine.
He's filing written statement. Challenging inter alia ছাপিয়ে দিতে বলে একটা বের করে দিতে। ঠিক আছে,
Great, clear.
দাও, 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 দাও।
My lord, Ms. Devjani Ghoshal is appearing for the petitioner. She is addressing in courtroom number 2. My lord, I have been requested to pray for
Not this week,
at 2 p.m. My lord, he wants to do it.
not this week, not this week. মান্থলি লিস্ট চলে গেল, থাকবে মান্থলি লিস্টে। হ্যাঁ, কি থাকবে?
My lord, can your lordship take it?
Yes, call the next matter.
Please, your lordship, this is a matter, my lord, if my lord recollects, the application for recalling filed by my learned friend was not with the record, and the interim order passed in the matter was passed till last day of December 2024. क्या ये करोगे था you? Should I begin? हाँ, तो हम नहीं बोल रहे. My lord, this is the last order of a coordinate bench granting me stay.
You are asking for modification of an order dated 10 September 2024.
But I read for recalling the order.
Recalling the order, 10 September.
Not needed, my lord, because since he has filed an revisional application against the order of the trial court seeking to deposit the rent in the trial court, since he had defaulted.
On and from May 2024.
Court had held that.
You go before the honorable court. You are asking for modification of the order. I can't take up. I know, I can't take up this matter.
My lord, he is not pressing the application now.
I'm not pressing the application that by can, my lord. I will not press my. In fact, my lord, I'm consenting, my lord, this revision application be allowed and be sent back to the trial court, my lord, for expeditious. You will deposit the rent at his own cost, at his own risk, my lord.
My lord,
That
default.
Whether the default is there or not, it will be taken up at the time of the.
Who has filed the revisional application?
My lord,
the
petition.
my lord.
Why?
My lord, what happened? 1 minute. My lord, what happened? There was a 5 days.
Why did you file the revisional application?
Yes.
From which order?
My lord, my lord will kindly see the order where there was a delay in filing, in depositing the monthly rent in respect of May 2024 for a period of 5 days. That was disallowed. By order dated 12th of July 2024. There was only delay of 5 days after going through that. An order was passed, even the recording therein about the judgment passed in Vijay Kumar Singh and others versus Amit Kumar Chamaria. So I came up with the revisional court and the revision.
I cannot take it for extension of interim order. What extension is this? This is not an extension.
No, my lord, extension is, my lord will kindly see the order of the 10th of September 2021 passed by the Honorable Court. Is in record.
Yes.
This extension was, there shall be stay of all further proceeding of ejectment suit number 1639 of 2001 passed by the learned third judge Presidency Small Causes Court at Calcutta till the end of month of December 2024 or until further orders, whichever is earlier. So I filed my application for extension is to this extent. But
Can.
no, I have filed it within time, my lord.
What is the can?
No, I have not filed. This was mentioned before time and it was listed before time. On the last day.
You don't want to press can? One? The learned advocate representing the applicant.
Get
কেন হচ্ছে না? ও ক্যালেন্ডারটা বদলে দিয়েছে তো, কেন হচ্ছে না? ওপরে দেখো, 9 Thursday, yes. Call the list, call the list. Yes, yes.
My application,
Why is upgraded, Mr. Sen?
yes, my lord, because on my submission, this is an application under order 13A. My lord, if I tell your lordship the facts, my lord, your lordship will be surprised to know how the bank and the assignee of the bank have defrauded.
Where is Mr.
But here, there has emerged 3 title documents in respect of one property. But this is a property which I had an agreement for sale with one Lodhas. Title document was given to the Lodhas and part possession was given. This was the principal agreement between my father and the Lodhas. Then, my lord, in 2002, suddenly I receive, my lord, if your lordship sees, 2004, I receive a 13-2 notice. Suddenly. In
Sir,
respect,
who are you representing?
he is the assignee of one of the alleged secured creditor.
Assignee of a secured credit.
One of the alleged secured creditor. My lord, what happened? Just give me 2 minutes.
Yes, no, I mean, asserting
Yes.
who is appearing.
Yes, my lord. So, my lord, kindly note a few dates. My lord, first in 2004, I have received a 13-2 notice from a UCO bank alleging.
start period, I had a point of maintainability.
I will come, my lord. I will address that. I know, my lord, why the maintainability is reached, but kindly allow me 2 minutes time to give your lordship the brief facts.
Yes.
Why
What
I
are you
am
challenging here and then go back. Just cliffhanger. You tell me what are you challenging and then you go.
I am challenging, my lord. This is a suit filed on account of a money which I had to give to the assignee of a secured creditor on the strength of a 13-4 notice issued by them saying that my property is the security interest. Since my dwelling house was being taken over, at that time, without prejudice to my rights and contentions, I gave them the amount which they had demanded.
Entire amount.
Yes, entire amount, because my possession is being taken over.
So 13-4 was not subject matter of challenge in the suit.
No, no. Now, thereafter, my lord, I filed a police complaint saying that I had never given any guarantee. My title deed was already given to one Lodhas. This is the second secured creditor who has purported to issue this notice. There is another secured creditor who has filed an OA before the DRT3. So there are 2 secured creditors saying that this property is secured on the strength of 2 different deeds.
Why did you not file a section 17?
Because because at that time I had no time. My property will be taken over. I gave that money. Now, my lord, when I filed a police complaint regarding this inquiry.
Even if you give that money, are you precluded from filing an application under section 17?
No, I may not be, but what now that proceeding was over because I got back that title deed. Because I paid the money, property was released from mortgage. Property, I got back the title deed. My only question before the authorities, police authorities, was that this is a racket going on between the secured creditors and my so-called purchaser who had agreed. So I called for an investigation to be done.
Your so-called purchaser is Lodhas.
He is one Lodhas, to whom I had given my original title deed way back. Then suddenly it comes to
You mortgaged it.
Yeah, no, not mortgage, agreement for sale. It was an agreement for sale to Lodha.
Along with the title deed.
I had given, my lord, why my father had given, I don't know. Even a part possession was given and the original title deed was given. This was one aspect of the matter. Then after that, suddenly 13-2 comes from a UCO bank. First from UCO bank. DRT proceedings are filed before the UCO bank, by the UCO bank. After that, another 13-4 notice comes from my learned friend's client, who is an assignee
And
of.
what happened to that UCO bank?
That proceeding was before the DRT.
What happened to that?
That proceeding was going on at that point of time.
Did you settle it there? No.
No. I settled it here with
Because the
this
title deed was lying with him.
because he's come to take over possession. That was the urgency why I paid the amount which he had demanded.
And got back the title deed.
I got back the title deed. What is now important is one that the police investigation was being carried on.
Yes.
There was an order of the division because they were not carrying on with the investigation. Lot of delay. I filed a writ petition. Ultimately, division bench passed an order that you have to conclude the investigation within a certain period of time. And if it is found that the deeds are not I have not executed the deed of guarantee, I will be at liberty to file a civil suit for recovery. That is the division bench order. Then, my lord,
Division bench order is there.
Yes, I'll show your lordship.
No.
Then, my lord, then an
When is the date of that order?
Yes. Division bench order, your lordship will get at 20th March 2020. 2nd March 2020.
Yeah, I get it. FMA 404 of 2020.
Yes, my lord.
Yes. No, from your list of this.
Yes, my lord, your lordship can.
Page number?
I'll show you. Page number, it starts at page 296. Relevant part, your lordship will kindly see.
Yes.
At page 300.
Yes. Very well.
Just kindly
continue.
Then, my lord, on the basis of this division bench direction, final report is filed at page 146. This is very important. This your lordship must see, my lord. Kindly comes to this once.
146.
146. 146, my lord, kindly comes to 148. This is the, let me place this, my lord.
Yes.
The brief fact of the case is that the FIR named.
Prior there, from which order you are coming here and what are you aggrieved, and thereafter you come there.
Yes. What? So this is an FRT which says
yes,
that the deeds of guarantee executed insofar as this bank is concerned and UCO Bank is concerned are all forged. Only deed which is the genuine deed is the deed which they have seized from the Lodhas. This is the FRT final report which they have given. After this final report, when I found that they have actually, my lord, I was compelled to pay the money on the basis of forged deed of guarantees, I filed the civil suit, saying that you have illegally recovered money under threat of dispossession without any deed of valid deed of guarantees being executed. So I am entitled to recovery of that money which I have paid under on the basis of your threats. This is my civil suit. I have filed, my lord, an order 38 rule 5. My lord, this honorable court in the division bench has passed an order for furnishing of security. They have challenged it before the Supreme Court. Before the Supreme Court, they considered that they will furnish the security. And before the division bench, they took the point of limitation, that the suit is barred by limitation. I will place the division bench order. Division bench has gone threadbare into that question and found that the suit cannot be said to be barred by limitation at the threshold. It is
no, your application for summary judgment has been dismissed.
Yes. Now, my lord,
you're challenging this.
I'll tell you, lordship, why. So this is the first thing. Then, my lord, a further fact has happened.
No, what is the urgency then?
No, I'll tell you, lordship, my lord. Kindly.
Yes.
So after this security has been furnished, they filed an order 7 rule 11. Order 7 rule 11 was dismissed. They preferred civil revision. That was also dismissed with cost. Then, my lord, what happened? A further very important fact. I filed an application before the criminal court for destruction of the 2 forged deeds, which they have seized from UBI and UCO under section 452 of the CRPC. Those purported deeds have been allowed to be destroyed by the criminal court. Whatever. I am not concerned. I have gone as per the provision of law. And this final report has not been challenged by them, where there is a factual finding recorded that those deeds of guarantee are all forged documents. Now I come to the civil court and say that look at the written statement. What could be a triable issue? There is no counterclaim. They have not filed a counterclaim for declaration that the deeds are genuine deeds. They are only denial that these deeds are genuine. Denial of my statement in the plaint that these deeds are forged and fabricated, they have simply denied that. My case before the trial court is, what will go to trial? They will have to prove by primary evidence that the signatures on those deeds are genuine deeds. Where is the question of proving once they have allowed the documents to be destroyed? There is an order of this criminal court which is unchallenged. There is an FRT of the criminal court filed before the criminal court. They have not asked for reopening of these facts by further investigation. So therefore, my humble question before the learned trial court was, in the trial, on what documents or on what basis it will be proved that these deeds are genuine? It is their onus to prove that the deeds are genuine.
Now the suit is proceeding before the commercial court.
My application has been dismissed for summary judgment on this plea.
I have seen that.
So therefore,
Proceeding before the commercial court.
just because it was pending here, the civil revision, my lord, we have asked for an adjournment before the learned.
Revision pending when?
Because it was
When did you file it? When did you?
well, it was filed first day, my lord, when your lordship was in the circuit bench. When your lordship was in the circuit bench, we moved it before the other bench. There we got just a simple prayer. That's on the one day, let it be adjourned.
No, if it assuming it proceeds also, what difference does it make? I'm not trying to ascertain from.
No, what will my problem only to this extent it will be, my lord. Then now issues will be framed and the documents will have to be disclosed and everything will go on.
Let it go on. I will post this for hearing and finally decide it. If in the meantime you get an order from this, matter ends, everything comes to an abrupt end.
But I will have to now present my evidence there. Well, that is my question. I am saying, my lord, I have got a vested
I'll fix
right.
it, Mr. Sen. These matters, commercial court matter, I'll not keep it lingering. I'll fix it. First available opportunity I have, I'll fix it. That has to be hard.
Yes,
I have to hear Mr. Dutt on the motion stage. This will not possible. On a returnable motion, I'll do this, not contested.
Then your lordship will kindly fix a
On
date,
a
my lord.
Thursday, yes.
Kindly fix a date, my lord, or we shall.
Now tell me what is the stage before the
Last day
commercial
ki
court?
hoyechilo?
Documents file kora just we have filed.
File those documents.
Issues will be framed.
Whatever you have in your custody, you have to disclose it.
That is
Unless you
well,
do it.
in
Case
fact, that has already been done.
Case management orders are there.
No, it will be passed now.
I've told me, Lord, we have filed our issues. They have not.
Yes.
Very well, we will file the issues that.
Mr.
But
Dutt,
question
you
is, my lord, I have a
if
vested
it is
right.
decided against you, if it is decided against you, the matter will abruptly come to an end.
Okay, it doesn't matter.
If it is not decided against you, there is no question to stall it at this stage. So I'm I'm not called upon you for that because I'm not staying this. But I will hear it out.
Asking for stay.
No,
I am not asking for stay.
I will hear it out.
But-
Finally. And you come ready on that.
Well, my learned
Because
friend is ready.
whatever he said, I have
My learned friend is
understood.
always ready, my lord.
No. Because it will be taking some time because he is trying to say today there is nothing to prove. So far as you are concerned, because those primary evidence has already been destroyed. Now you are saying that he has destroyed it.
Order of court. His document.
At
order
his
of
instance,
court.
it was destroyed.
Destroyed without any intent. So the only evidence in a suit which he is saying to be delivered up and cancelled has to come to a conclusion. So now that he has destroyed it without intimation to me, now he comes to the court and says,
Why will I intimate to him? The state has the primary party.
Go to the court and the court has to come to a conclusion that the police report
before a civil court is a finding, is the basis on which a court can come to a conclusion that the signature is forged.
I am, my lord, only one thing, my lord. I am not required
I am
to
putting
prove to
myself
the
in the-
negative.
I am putting myself in the position of the judge to try and understand that somebody has come and said that this document is forged. Document is destroyed. You come to a conclusion that this document is. This is the problem my learned friend is facing.
No.
That's why he wants to get a summary judgment.
But let
Doesn't
me
want to go into
let me place it other way around. My learned friend is the bank who has
You have been called upon to put in security.
Of course, because I have.
Prima facie, it has been, you did not question the FRT.
no, did not. Did not.
But the thing is this, that even if I have come clean and deposited my fund, that doesn't give away my right to say that he has to still prove his case.
Very well.
Well, only one
I'll
thing.
fix it.
Well, only one thing.
Cannot be done today, Mr. Sen.
No, I am not saying that. I am not saying that. It is just placing the
No, I'm not seeking any explanation at this stage from you. I'll seek it.
I am relying upon a deed of guarantee. Who will have to prove it?
Having heard the learned advocates are pleading for the respective parties. Sir, revisional application.
What happens with this, my lord? Mr. Sen may say that he had agreed to a hearing.
No, no.
without the question of it.
No,
On
no.
what the court will think. I'm on what Mr. Sen will think.
I have not recorded your agreement also. He was insisting that only in January, and you are only agreeing to the dates, if at all. And that too I have not recorded. Why will I record and prejudice your client? Why will I? Mr. Sen's client has to succeed first. Well, I'm not prejudiced to your client in any way.
I'm only apprehending.
I can keep it on 13th. Take your chance, 13th.
13th, let us take a chance.
13th February করে দাও ওটাকে ডেটটাকে 13th করে দাও। If it is not taken up, then again I'll fix it on another date, future date. Because by that time the dates will be, it is entirely up to you. Well, nothing will happen, Mr. Sen. 1 month time, practically, effectively 1.5 months. 1 month time.
Actually, I am caught in a crossfire because I have obtained order from Supreme Court for the suit to be disposed of. So that I can't also pray for adjournment.
No, don't pray for stay. In this matter, no question of stay. Either I allow it, it is allowed, or I don't allow it.
And in any event, this is only for part of the claim, and I'm not asking for the entire suit claim to be disposed
So
of.
let the suit continue. Why will you ask for stay?
No, I'm not asking for stay.
It will be taken up on that day. Unless you choose to close it. There's another difficulty. পরেরটা ছাতা যেরাম ছিল ছাতা দেখো দেখো পরেরটা দেখো
Lordship, I am for the petitioner, Lordship.
I'm for the defendant. My lord, I'm being led by Mr. Sudhir Mehta.
Yes, sir. Continue. No password, sir.
Lordship, the plaintiff is the petitioner before your Lordship. Now, Lordship, I filed a commercial money suit. In that suit, Lordship, the other side filed a counterclaim. Now, in connection with that counterclaim, Lordship, I filed 2 applications. One, Order 7, Rule 11, and another, Lordship, application under Order 8, Rule 6C. By the order impugned, Lordship, both these applications were rejected. Challenging that, Lordship, I've come up before your Lordship. Now, Lordship, my Order 7, Rule 11 was based on the point that, Lordship, the defendants, Lordship, before filing their counterclaim, has not complied with the mandatory 12A provision, Lordship, of the commercial pre-litigation mediation. And regarding this Order 8, Rule 6C application, our case is that this court did not have, Lordship, jurisdiction to hear the counterclaim.
One very interesting point, madam.
Lordship.
In this case,
Lordship.
when the suit was filed,
Yes.
you had exhausted your remedy.
True. Yes.
Of pre-institution.
Yes.
Yes. Mediation.
Yes.
In that pre-suit mediation, all points had come up.
Regarding my claim, but his
Also his
counterclaim,
claim.
no.
Also his claim.
No, Lordship, his counterclaim is totally based on other contracts, which are not covered by my suit, Lordship.
Based on the same contract.
No, that I shall place, Lordship. Of course, that I shall place.
Place it, madam.
Lordship. Lordship, so Lordship will kindly keep, Lordship, since it is Order 7, Rule 11 in connection with the counterclaim, only the counterclaim
Please
will be
remember
taken.
one very important aspect. here.
Lordship.
The Act contemplates
Lordship.
pre-institution mediation.
Lordship.
It does not contemplate 2 sets of pre-institution.
No,
mediation.
of course not.
Only 1 set. In that mediation, your claim and his counterclaim, whatever be it, has to be included.
No, but we did not know about his counterclaim. It ended in a non-starter. They did not participate. And his counterclaim is based totally on a different sets of facts, Lordship. They are not connected with my suit, Lordship. Because that is also my case in my Order 6 Rule, Order 8 Rule 6C application. That this court does not have jurisdiction to hear
You
out.
can rely on a Delhi High Court judgment.
Lordship,
Delhi High Court judgment anyway. Show me that Delhi High Court judgment.
that was, Lordship. That is with your Lordship's record.
Aditya Birla Fashion Retail.
Yes.
Aditya Birla Fashion Retail, tell me this.
Lordship.
Paragraph 15.
Yes. Paragraph 15 onwards, Lordship, it starts.
Here a commercial court sec degi.
And ultimately, the conclusion is that Lordship at paragraph 57.
Court sec. Patla hobe jabe.
It was also a case.
Was this suit in
Lordship.
this case
Yes.
instituted as a commercial cause?
Yes.
Show me that facts.
The my suit, Lordship?
No.
This one. Lordship, paragraph 2. The last line. Filing of commercial suit seeking recovery. And paragraph 7, Lordship, defendant also lodged a counterclaim on such and such seeking rentals, etc.
No, thought it fine to file a commercial suit before
Lordship, paragraph 8, important.
file an application under.
Was also involving commercial dispute and therefore registered as a commercial suit.
Yes, 12A was complied with in this case.
No, it was
Yes, paragraph 3.
not. That is the plaintiff complied. Defendant did not.
Where does the act contemplate that, madam?
In this case, Lordship.
Yes, where does the act contemplate that?
Yes, but that
Act contemplate that.
No, the act does not say. But Lordship, kindly come.
The court may have said this.
But Lordship will kindly see.
You see, madam,
Order
consider
8.
it from a different perspective, madam. Consider it. We are discussing aloud. Consider it. Come to 12A first. Just understand this. Do you have a book, madam?
Yes.
Kindly place it, madam.
Yes. 12A pre-institution mediation and
A
settlement.
suit which does not contemplate any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as prescribed.
Lordship.
Now, come to 5.
Lordship.
4. Read 4.
If the parties to a commercial dispute arrive at a settlement, the same shall be reduced into writing and shall be signed by the parties to the dispute. And
What does it contemplate, madam? Let us understand.
Yes. Suppose, Lordship, there is a dispute, commercial in nature, Lordship. To expedite, Lordship, the proceedings, so before going to the court, the parties will try to settle it before the mediator.
Correct.
That too within a specific period of time.
Now, if while settling the dispute, there are counterclaims, the counterclaims will also be settled in this. Consider the situation.
Yes, of course.
I'm not asking you to, I will not accept your agreement in any way.
No.
We are discussing this. So,
there should be.
So it can be settled in this fashion.
Lordship.
So therefore, a party, I'm saying not a plaintiff, a party, before instituting a suit, initiates the mechanism of pre-institution mediation.
Lordship.
And in course of that mediation, the parties agree to a settlement.
Yes.
If a settlement is reached, after the settlement is reached, can the defendant make a counterclaim? 4 and 5 cannot, is precluded.
No, provided, Lordship, that those disputes were
are commercial
discussed in the settlement.
Assuming they are not. Assuming they are not.
No, then of course that does not, Lordship, preclude him from filing a suit. That cannot be. Suppose, Lordship, there may be plenty of disputes between the parties. But suppose today I seek to file a suit in respect of particular
Very well.
things, Lordship.
Very well. Now, particular aspects you seek to file. Now there is a settlement, and in
Yes.
course of a settlement, will it only be restricted to your claim, or can it include counterclaim?
If they participate, of course, then everything will, whatever is discussed in the
Without
settlement.
without the settlement contemplates participation. Settlement contemplates
yes,
participation.
Yes.
Without their participation, settlement cannot take place.
True.
So therefore, if a settlement is reached, that will not only be with regard to your interest being secured, but their interest also being secured to whatever extent. I'm not going that far, counterclaim or not. So can it not be said, therefore, without reading the judgment? We'll read the judgment later.
Lordship.
That the pre-institution mediation not only incorporates the right of one party, but the right of the other party
Yes.
to bring about a settlement.
In respect of the dispute discussed in the settlement.
Correct. Whatever is discussed.
Yes.
Whatever is discussed.
Yes, absolutely, Lordship. And if, Lordship, a settlement is arrived at, thereafter, the parties will be precluded from filing a suit on those points.
Very well. Now
But
come to the
here-
judgment. Now come to the judgment.
But before that, may I place the
So come to the come to the judgment and
Judgment
then come
first.
back. Which paragraphs you want to place?
The order impugned, Lordship?
No. Judgment. This judgment of Aditya Birla.
Yes. It
Fashion-
starts from, Lordship, paragraph 15. It has been discussed, and the ultimate conclusion, Lordship, has been reached in paragraph 57. That is at page 17. Paragraph 57, I am placing, Lordship. In view of the above said discussion, it clearly emerges out that the process of pre-institution mediation is mandatory for every suit involving a commercial suit, and no distinction can be drawn when it comes to a counterclaim involving a commercial dispute and not contemplating any urgent relief. As per the mandate of Patil Automation Private Limited, any such suit which has been filed without taking recourses of Section 12A of the Commercial Act needs to be rejected under Order 7, Rule 11 CPC. Therefore, to that above extent, observation.
Patil Automation says something else.
That
Patil
is
Automation is
compulsory. But
Yeah.
here it says that even in cases of a counterclaim also, that is also mandatory.
a counterclaim does not, because the statute does not recognize any separate recourse. 1, 2, pre-institution mediation was mandatory. You had initiated the process.
Yes.
That failed.
Yes. But in respect of my dispute, here, Lordship, in this case, my dispute and his dispute is different. Though they have filed a counterclaim, but his dispute, he is also seeking money, but in respect of different contracts.
Any
which-
other judgments you have on hand?
This is, Lordship, pat on the point. The other all judgments
Show me.
say that, Lordship, pre-institution litigation is mandatory. But on this exact point only
Pre-institution
this.
litigation is mandatory. There is no dispute with it.
Yes.
Even the Supreme Court, while saying that no leave is necessary, has went on to say that no, this Patil Automation has to be followed, and therefore this is mandatory. There is no difficulty with regard to that. The only stumbling block is only on the issue that whether it is necessary for the court.
Because, Lordship, a counterclaim is a separate suit in nature, Lordship. Lordship, order 8, Lordship, Rule 6A4 says the counterclaim, Lordship, should be treated as a plaint. And even if, Lordship, suppose today my suit gets dismissed for default or anything, Lordship, a counterclaim that continues, Lordship, to go on like a separate suit. So, Lordship, if I am, Lordship, bound by the rigors of 12A, they also have to, Lordship, follow that. Particularly when, Lordship, here their counterclaim is not on the same cause of action of my suit. That is the main problem, Lordship. I am seeking money in respect of certain contracts. And, Lordship, they are seeking money in respect of some other contracts.
Yes, madam.
So that is why, Lordship, my cause of action and their cause of action is not same. So that dispute, their dispute, Lordship, were never, Lordship.
You had only placed order 7, Rule 6A.
6A, yes. 6A subsection 4.
That was your only point.
Yes. That is in my order 7 rule 11. And Lordship, I also filed another application under order 8 rule 6C. Saying that Lordship, the counterclaim should not be accepted since the court did not have jurisdiction to entertain that counterclaim, territorial jurisdiction. Because Lordship, in order to decide a counterclaim, the court also
Then you are
has
giving
to.
up the first point.
No, both the points. Why should I give up? No, I'm not giving up both the points, Lordship. I will urge both the points.
No, I'm just.
No, there are two, Lordship. I made two applications. In order 7 rule 11, it was solely based on 12A. And Lordship, my order 6 rule.
Your application under.
Yes, at 52, page 52, Lordship.
This is order 7 rule 11.
Yes, Lordship.
This is purely based on 12A.
Yes, paragraph.
You have argued already. Wait,
Yes,
I
yes.
understand. And what is the next one? Which one?
Another is, Lordship, that is at page 50. That is at
58?
page 60. No, not 60. Lordship.
Yes.
60. Yes, 60. No, I cannot. 60.
60.
60.
60A.
All right.
68. Order 7, rule 6C.
Or order 8, rule 6C.
Order 8, sorry. Order 8, rule 6C. Yes.
Lordship, kindly comes to paragraph 3 at page 61. The defendant, along with its written statement, has filed a counterclaim. After perusal of the counterclaim filed by the defendant, it transpires that the alleged counterclaim by the defendant is for some other contracts, which is beyond the scope of this present suit. As such, the goods under contract have no relevance in the instant suit in any manner whatsoever. The alleged counterclaim filed by the defendant ought to have been filed by way of separate suit. And Lordship, also at paragraph 6, next page at page 62. At this juncture, it may be submitted that as per statute, order 8, rule 6A4 of the Code of Civil Procedure, a counterclaim must be treated as a plaint and shall be governed by the rules of the plaint. When a plaint is filed in form of a suit, the plaintiff files such suit as per direction as explained in Section 20 of the Code of Civil Procedure. In this case, when the suit was initiated, the jurisdiction of the learned court was where the defendant is having their place of business. It is further stated that when the counterclaim is filed by the defendant steps into the shoes of the plaintiff and becomes plaintiff, and the OGO, that is my client, becomes defendant in the counterclaim which is filed. Such being the changed circumstances, the defendant has to file this counterclaim before this learned court, which has no jurisdiction to entertain such counterclaim. A plain reading of Section 20 of the CR.
Why doesn't have jurisdiction? Because why? No part of the cause of action as there isn't.
Yes. They have not even said that in their counterclaim. That is why Lordship kindly allows me to place the counterclaim. It's a very small counterclaim, Lordship, at page 46. They have not stated that even. No, the counterclaim is here. Lordship, page 46.
Yes.
Paragraph 41 onwards, Lordship. Now the defendant files his counterclaim hereinafter. Now 42. In respect of the contract and invoice mentioned in Annexure B, the defendant has lodged a equity claim of USD such and such, equivalent to such and such, on account of excess moisture and outthrow more than permissible limit, which were required to be paid by the plaintiff to the defendant, but the plaintiff has failed and neglected to make the payment thereof without any reason whatsoever thereto. The defendant made payment thereof of the invoices on the basis of letter of credit DP basis. 43. A sum of rupees such and such has become due and payable to the defendant by the plaintiff together with interest such and such on account of quality claim as made by the defendant. A sum of such and such on account of interest. 44. In respect of contract number such and such, this is also not my contract, which I claimed in the suit, dated such and such for export of such and such by the defendant to the plaintiff, Value of goods which were lost due to long storage risk for which was passed to the plaintiff is liable to pay the balance amount to the defendant. A sum of such and such has become due and payable by the plaintiff to the defendant on account of export contract being annexure E to the written statement. The plaintiff is also liable to pay interest such and such, a total sum of such and such has thus become due and payable. 45, the plaintiff is liable to the defendant to pay such and such equivalent to such and such. 46 is the total sum in a tabular statement. Now, 47, no part of counter claim of the defendant is barred by limitation. 48, the defendant has paid court fee of such
Is
and
it
such.
necessary to plead part cause of action?
Lordship.
Is it necessary to plead that in a double?
Lordship, Lordship will kindly take up Order 7, Rule 1E.
Order 7, Rule 1E.
Lordship.
Madam?
Particulars to be contained in a plaint.
Oh, you are trying to bring in an analogy. It's to be treated as a plaint.
Yes, of course. Lordship, that is what Lordship Order 8 Rule 6A4 says, that a counterclaim shall be treated as a plaint. So,
Treated as a plaint.
yes, so whatever is there in respect of procedure, everything that has to be followed in case of a counterclaim. Lordship will first see Order 7 Rule 1E. The fact constituting the cause of action and when it arose.
For instance, madam, consider a situation where a leave is granted under clause 12 of letters patent for instituting a suit before this honorable court in the original jurisdiction. Now, by an amendment, if certain facts are pleaded or a claim is incorporated in the body of the plaint, which is otherwise not barred by the plaintiff, which disentitles the plaintiff to the leave, the fresh leave is required to be obtained or leave can be revoked. But there is no such provisions for the defendant is concerned. When a defendant comes up and makes a counterclaim, it is that the language is very wide. Come to order 8.
Lordship.
Come to order 8. Language is very wide apparently.
Lordship will kindly see.
Yes.
Order 8 Rule 6A4.
4. Yes, madam.
The counterclaim shall be treated as a plaint and governed by the rules applicable to the plaints. So whatever rules is applicable to the plaints will be applicable to a counterclaim. So in the counterclaim also, Lordship.
First come to 6A.
Lordship. A defendant in a suit may, in addition to his right of pleading a set off under Rule 6 set up by way of counterclaim against the claim of the plaintiff, any right or claim in respect of a cause of action accruing to the defendant against the plaintiff either before or after filing of the suit, but before the defendant has delivered his defense or before the time limited for delivering his defense has expired, whether such counterclaim is in the nature of counterclaim or for damages or not, provided such counterclaim shall not exceed the pecuniary limits of the jurisdiction of that court. But Lordship, that court has to have jurisdiction.
Continue.
Such counterclaim shall have the same effect as a cross suit so as to enable the court to pronounce a final judgment in the same suit, both on the original claim and on the counterclaim. The plaintiff shall be liberty to file written statement in answer to the counterclaim of the defendant within such period as may be fixed by the court. The counterclaim now is 4. The counterclaim shall be treated as a plaint and governed by the rules of the plaints. So, Lordship, his counterclaim should have all the pleadings which are
You are saying, although if he does not succeed under your petition, if he does not succeed under 12A, still then under 6.4, it still has to succeed because there is nothing there in the written statement.
Lordship. And Lordship, Lordship, these are all defects. It will not preclude them from filing again. Even today, if its counterclaim gets rejected, it will not preclude, it will not cause us a
Object is to avoid multiplicity of judicial proceedings also.
True, Lordship.
But at the same time, if this is not there, that cannot be allowed. But can it be rejected on that ground? Order 7, Rule 11, can it be rejected?
Lordship, there
Yes, so far as Patil automation is concerned, 12A rejection.
Lordship.
But 6-4 rejection.
Lordship, they are
Or a
governed by
court should afford him with an opportunity to amend it.
But Lordship,
No,
that will
you
also not
tell
Lordship.
me, you assist the court.
But even if we do that, Lordship, that will not, Lordship, take away that thing, that 12
Because the moment he discloses cause of action, then he will be precluded from instituting that counterclaim in these proceedings. Because those facts are not there.
Lordship. It has to be sent to the Lordship, then Order 7 Rule
Court
10.
having appropriate jurisdiction.
Lordship. It has to be sent there.
Yes.
My lord, gives me time till 2 p.m. My lord.
No, no,
My
no.
senior Mr. Mehta. 10 minutes. 10 minutes.
Very pay costs.
10 minutes.
I'll adjourn it, pay cost.
10 minutes time, my lord.
And the matter has gone on for more than half an hour. What are you saying? At the very first moment he had said.
They will come in 10 minutes.
Pay 5,000 rupees cost. These matters are fixed. You are aware how these matters are fixed. It's a commercial suit. On the prayer of the learned advocate representing the yes, sir.
But Lordship is not appreciating the first point, 12A.
I've kept it open, madam. I've not said that I've not decided it.
Lordship.
I'll still hear you once again.
Lordship.
But I find it more difficult for him to come out. So I've given an opportunity. Let me explain this part. Then I'll come back to you. I've not said that I'm not with you on that point at all. But you know, as I'm a little expressive. And so it is always better
Yes,
to
of
let
course.
the advocates know
I will also try
which
to find
way it is going.
out if there is more such.
Try and consider this aspect, madam, that once 12 is the pre-institution mediation proceedings is initiated, everything under the sun between the parties can be discussed there. And considering 4 and 5, settlement can be reached. Settlement can be reached within the suit, outside the suit, and here there is no suit at all. Here there is no suit at that stage. So everything can be drawn in. Why they'll be precluded? So that is a point you have to answer. I've seen the Delhi judgment, but still then you have to point you have to answer.
Lordship.
Come back to all that. But this is another point that you have placed before this court. Come back, madam. First, and please be there. এর আগে প্রথম মামলা করে দিও ওই যে হ্যাঁ কন্টিনিউং বলে রেখে দিও কন্টিনিউং বলে রেখে দিও রিটার্নেবল মোশনে কন্টিনিউং ফার্স্ট ম্যাটার হ্যাঁ রিটার্নেবল মোশনের ফার্স্ট ম্যাটারটা হ্যাঁ সাপ্লিমেন্টারি লিস্টে দিয়ে দেবে না তাহলে তো হয়ে যাবে না I'll come back and get ready man on that date will be over whichever it goes.
But for the petitioner, my lord, this matter relating to my lord, your lordship, that order has been passed under order 21 rule 97, my lord. My lord, this is the law, my lord. If it is passed under 90 rule 98, my lord, it may be decree. But my lord, there is an exception, my lord. My lord, where there is a jurisdictional error, or my lord, there is order has been passed beyond without considering the fact, my lord. There is a compromise decree, my lord, passed on 13 January 2023, and my lord, thereafter with this petitioner, my lord. But my lord, suppression of material fact, that the application for my lord execution case has been filed, and my lord, the petitioner herein filed application or written objection to the said application on twofold ground, that the first of all, due to compromise degree, the opposite party have no cause of action against the petitioner, and two, my lord, the suppression of material fact. The said execution application has been filed under suppression of material fact. There is no whisper of the compromise decree, and thereafter, my lord, the learned court below directed the petitioner herein to file an application disclosing their possession, demonstrating their possession of the in the property, my lord. The application has been filed, and my lord, to that effect, my lord, the annexure D, my lord, my lord, the plaintiff therein has filed an application, the reply to the said application. My lord, kindly see at page 51. They have also, my lord, prayed, accepting the, my lord, may I read, my lord? Page 51. And the impugn order, my lord, there is some defect also to that fact, my lord.
Yes, what is your challenge?
My lord, challenge, my lord, kindly see, my lord, at page 51. That is the reply that starts from page 41, my lord. That starts from page 48, annexure E, my lord. That is the affidavit in reply filed by the petitioner against the application under section 151 CPC filed by the opposite party number 329.
This was rejected.
My lord, that's why, my lord, kindly, my lord, kindly come, my lord, at
You are 329.
my lord.
Your application was rejected.
That's why, my lord, I have come, my lord. Kindly see page 51, my lord, once, my lord. They have prayed. I say
You
that
are challenging this order only on the ground of rejection to that extent.
my lord. My lord, page 51, my lord, paragraph 11. I say that there is a compromise degree between ourselves, decree holder, and the opposite party number 329, and as such, the learned court is required to execute the decree dated 13th January 2023 by vacating the decretal premises with the help of police assistance, save and except the room which are stated in paragraph number 5 of the application under section 151 of the CPC filed by the opposite party number 329. My lord, the petitioner accepted that, and they have prayed. Beyond the prayer, the executing court reject my application and grant the police help in disguise of the opposite party number 1. Who is the objector? We are not the objector. My lord, kindly see, and even at my lord, My lord, page 23.
No, 7 except paragraph 5 of the petition. Where is that paragraph 5?
That, my lord, at page, that is at page, my lord, 42. And also, my lord, plan has been annexed with the same. Page 42.
What is your application 151? Place it.
My lord, that is at start from
Page 41.
page 41, my lord.
Yes. Yes.
My lord, may I read?
Yes.
That the above ejectment suit number such and such has been decreed on compromise between the plaintiff decree holder and the judgment data number 329 and the conditioner mentioned in the said compromise agreement, and without complying the terms and condition of the said compromise decree, the decree holder put the decree into execution and made the present application as judgment applicant as judgment data number 329 in the instant execution proceeding with the other judgment data without segregating the status of the judgment data with the present applicant and judgment data number 329. That the decree holder filed the execution proceeding on whole scheduled property mentioned in the plaint, but the whole property mentioned in the scheduled plaint is not executable as there is a compromise decree on which the decree was passed between the decree holder and the judgment data number 329. That on the judgment data, that so the judgment data number 329 have filed a written objection against the applicant under Order 21, Rule 97 of the Code of Civil Procedure, stating inter alia the grounds for which the said application is not maintainable and prayed for dismissal of the same. That now the judgment data number 329 states that they are in possession of the rooms in the suit property mentioned in the schedule of the plaint and the described by the floor as under. On the ground floor, room such and such, on the first floor, room such, and the second floor, room such and such, total area of 11227.
Where is the execution application and where is the compromise decree?
My lord, that is at page, my lord, 23. That start before, my lord, the relevant portion is the page that is 23, that is 11, paragraph 11b. After getting the sanction plan, the plaintiff immediately informed to the defendant to give time not above 30 days to vacate the suit premises and for getting sanction plan for the new building. They will give the NOC to that effect. But my lord, after the passing of the judgment compromise decree, no notice has been served to the defendant. And in the
Where is their execution application?
That is at page, my lord, page 29. Start from page 29. And there is no whisper of the compromise decree.
Where is column 10?
My lord,
Where is column 10?
my lord, only that has been served upon us.
Sir, execution application, have you seen it, sir?
My lord, there is a form.
Only one form, that column 10 is there. Where is that column 10? Prayer. These are summons.
My lord, that is their application for police help, my lord. And they put all the total premises, but in their petition, my lord, they have not stated about the compromise decree. But the opposite.
How do I know? Where is their petition? Yes?
My lord, this is a miscase, my lord.
Page 29 is order 21, rule 97, your application.
No, my lord, it is their application.
Order 21, rule 97.
They have filed, my lord. Kindly see who is
Who is filed the execution application?
my lord, the plaintiff, my lord.
And who are you? Defendant numbers 3 to 9?
Defendant number 1A to 2F to 2A
Who are
to
you?
2F. I am the defendant there.
Defendant numbers 3 to 9?
Defendant number 2A to 2F.
You are defendant numbers 2A to F.
My lord. After substituting. But in the execution petition, they have put us as the opposite party number 3 to 9.
3 to 9.
3
Opposite
to 9.
parties numbers 3 to 9. And in the compromise decree, you are defendant numbers 2A to 2F.
2F, my lord.
Who filed the application order 21, rule 97?
They are filed, my lord.
Why will they file? For police help, only for police help. Only for police help. On obstruction.
But the defendant number 1 obstructed, my lord. Because against them, the ex parte decree has been passed. There is several defendants in the suit, but against the defendant number 2A to 2F, compromise decree has been passed. But against the other defendant, the ex parte decree has been passed.
Challenging the order
Clear blood.
And for the opposite party husband.
My lord, kindly recollect this matter, my lord, just before the vacation, my lord. So section 24 application wherein the wife, my lord, paid for transfer of the mat suit filed by the husband from my lord Shiuri to the district of Bankura, Bishnupur.
Yes.
My lord, I filed the affidavit in opposition. There are many grounds.
No, no opposition, sir. No opposition in revisional application. You tell me, sir.
My lord, basically the point I
Section 24.
Section 24.
You are the husband.
I am the husband. I have already there is a DBR matter pending there.
Where?
Bishnupur.
Vishnupur. And I have faced.
Where are they seeking transfer?
My lord, to Bishnupur. Because the husband is coming at Bishnupur to attend the DB
My
procedure.
lord, kindly, I have filed an opposition. In that, I have stated particularly because I have been heckled and harassed by the relatives of the wife because they have some influence in the Vishnupur court.
I'll direct the police authorities to provide adequate assistance.
Durgapur, last occasion, if your lordship remembers, last occasion, your lordship proposed at Durgapur, a neutral place where.
No, if you are not facing problem by his family relatives,
My lord,
police, I'll direct the police.
My lord, kindly comes to my opposition, my lord. Not only matter of police, my lord, there is a distance problem also, and also of me getting a suitable advocate.
Law does not permit that. What can I do, sir?
My lord, law is there, my lord.
Show me the judgments on this.
My lord, one minute.
That the third place can be
Distance
fixed by
will
the
apply
court.
to him. Distance will not apply to me. As per his
No,
my lord, argument.
I am seeking a meet. My lord, can you see
Now.
one page from Supreme Court?
A different point altogether.
My lord, there is a point because I have an opposition. I filed an opposition. I filed some documents also.
What document? Show me.
My lord, kindly comes to the office.
Oh. When did you file it?
Last time. Before the vacation.
Nothing is recorded. When did you file it?
No, I have filed.
You filed opposition? Yes.
My lord, kindly comes to page 18 of the application. This is an annexure. This is an RTI application that I have filed before the learned Honorable Chief Judicial Magistrate. First question is whether the husband is saying whether my father-in-law Chandrasekhar Banerjee of Bishnupur Court, Bankura, son of date so and so, was in service at Bishnupur Court, Bankura district, and retired from there.
He'll influence the judge.
Not judge, but the procedure. But I am facing choosing the advocates there. I have been harassed, my lord. Kindly see, I have filed another. My lord, kindly see goes to this.
Yes, state showing.
Whether the below mentioned relatives of Shekhar Chandra Banerjee are engaged at Bishnupur Court either as staff or enrolled advocate under your judgeship or not. Number 3.
I get you. I'll ask him. Any other point? I'll ask ascertain from him. He'll tell me whether they're engaged. So, right to information is not necessary. I'll ascertain from him. He'll be giving me a correct picture. Whatever he client says so. So you tell me. Yes.
I have been physically assaulted, and I have filed a report in the GD. It was not being accepted physically over there. I had to by post send it by post. But it kindly comes to page 20. Kindly goes to.
Who's Shweta Banerjee?
Shweta Banerjee is one of their leaders. this is my case, my suit. If in my suit, Dominicus writers.
No, not in matrimonial proceedings. Sorry, sir.
My lord, at least
Don't open your mouth on that, sir. It will go against you. Please, sir, wait. I'm trying to find out whether there are any other things, sir. Your complaint was not received by the police.
not received in the police station. I have to by post file. Another judgment of the Supreme Court.
Wait, sir, judge. Yes, sir. He's facing problems.
My lord, not a single problem here.
No, this letter.
Later, what he suggests, my lord, kindly come.
Has the police taken steps?
My
I'll ascertain.
yes,
Has the police taken any steps on this or not?
my lord, can
Has any
my
case,
lord,
because this
my
is
lord,
enough
we are-
material
we
is
have
there.
been given to the police, informing that, my lord,
No, any case has been
no.
initiated.
my lord, if there is a, my lord, he has, in 2023, he comes and files a, my lord,
It was not accepted by the police.
police, my lord, he files.
No,
a
what
PU.
then you do
Then
thereafter? What after?
2023, this is
Thereafter, they just
2025.
He just
And
called
in
me
every
over the
occasion,
phone.
he appears in court.
Just
Yes.
called me over the phone and said that we have received your complaint, we will see, but nothing else. And after that even, whenever I am going, I am apprehending there is some problem there because I am not.
2000, my lord, kindly see, my lord, the match shoot is of the proceedings are being, my lord, in Bisupur court for a long time. There are other, my lord, this.
I'll ascertain from the public prosecutor in that case.
Yes, my lord can.
Because you see, at the end of the day, if his situation is disturbed, then the judgments he'll try to show. There are some judgments also.
But my lord,
And
he has
those
to
will come
show-
into play. But simply because he tries to say that the distance is a factor, those are not for consideration at all. Because distance is a factor for the wife, and as an husband, you have to make arrangements. No, you have to make arrangements for that.
But here, my lord, here, my lord, he regularly appears.
Did you appear before the police authorities?
I've gone.
Did you appear
No,
pursuant to that notice?
I approached them.
Or kindly see the.
No, page 21. Did you appear?
Yes. Then they said that we are going to look into the matter.
My lord,
Nothing more than
my
that.
lord, if he appears, my lord, why he has sent this through post, my lord?
This is the first instance.
Because he has sent reports, he is not accepted.
Which one?
That letter was not accepted. I'll ascertain
Yes.
from the police. I'll sub the director GP to appear or the public prosecutor.
Man,
Tell me, you tell me.
the, my lord, TP can.
Who can really assist the court? I want to know only ascertain with regard to this complaint, whether veracity of the complaint, I want to test it out, and whether any steps has been taken by the police, whether at all he has reported. If he has not reported to the police, 21, page 21, he has not reported, matter will come to an end forthwith. Forthwith, the matter will come to an end. So I want to test it out. Let a copy of the Placing it. না ফেরত দিয়ে দাও না ওটা দিয়ে দাও।
আমরা একটা করে দিচ্ছি জজ সাহেব বলেছে
You also complain. দুটোর সময় কি আছে? Monthly list আছে তো? হ্যাঁ, monthly list আছে। Correct.
My lord, with
I'll-
regard to item number 9, it is made not this week. Kindly fix it on, not this week, when it will be coming on January month.
Everybody you want?
No, I want it on Tuesday, 7th January.
I appeal for the petitioner.
Yes.
My lord, my mother was a tenant under the landlord opposite party number 1 and 2.
Yes.
He died on, my lord, 8th of January 2019. My lord, after 2 years, in 2021, the opposite party number 1 and 2 took out an application, took out a suit, my lord, under 2G of the West Bengal Premises Tenancy Act. Now, my lord, section 2G provides that, my lord, son, daughter, and son and daughter of predeceased son, who was ordinarily residing with the tenant till the death, and who were dependent on him, and who do not have any alternative accommodation, shall have the liberty of 5 years. Now, my lord, I, being the daughter, who was ordinarily residing at the time of death with the tenant, took out an application under, it took out a composite application under Order 7 Rule 11 read with Order 14 Rule 2. Since 5 years gap has not been elapsed till since the date of death. Now, my lord, Order 7 Rule 11 I sought for 5 years gap. Order 14 Rule 2 in the alternative. If Order 7 Rule 11 is not permissible to the court, he can sought for a preliminary issue. He can set out a preliminary issue over the fact of 5 years. Now, my lord, that application was rejected, observing me to be a trespasser since the date of death of my mother. That was the observation made by the court before trial, my lord.
What is your application?
Application?
What was your application?
Application, my lord, is at page 23.
Order 7 Rule 11 to
Page,
fight.
Order 7 Rule 11 read with Order 14 Rule 2 at page 20.
Rejected. Order 7 Rule 11 was rejected.
Order 7 Rule 11 was rejected, observing me to be a trespasser since the date of death of my mother. Yes. Well, kindly sees the order.
Order 7 Rule 11 rejected. Your application for Order 7 Rule 11 on what ground?
Over the 5 years gap has not been elapsed. Admittedly, 5 years gap has not been elapsed. 2G provides.
Triable, sir.
Yes. If that is triable.
That is triable, sir.
My lord, if that is triable, then
whether you are a dependent or you are not a dependent, these are triable, sir.
Yes. My lord, if that is triable, then my lord, I have sought for an application under Order 14 Rule 2 also for framing preliminary issue. That can be done.
Married daughter.
That can be done.
You are a married daughter.
Married daughter. But residing with the tenant, and I was dependent on him. With the same premises.
Married tenant. Married dependent.
Married
dependent.
Married daughter dependent of.
I'm asking you.
Yes.
Married dependent.
Yes, that is my lord.
Married dependent daughter.
Married dependent daughter.
How are you dependent? On whom you are dependent? On your husband or your mother?
My lord, there is my lord, matrimonial turmoil between my husband.
Turmoil, you're divorced.
Not divorced, but that is
asking for alimony. Are you asking for alimony?
Alimony from the my lord.
I will record that you are not interested to stay with your husband. I'll record here.
Yes, there
and you are seeking a decree for divorce.
Matrimonial
and that you will not seek for alimony from your husband. I'll record all this. You want?
My lord. My lord, in the plaint also.
You are ready and willing to put your marriage at stake.
My lord, in the plaint also, my lord, they have
ready and willing to put your marriage at stake.
My lord, there is matrimonial turmoil, my lord.
Turmoil?
Matrimonial, my lord, disturbance, my lord.
Disturbance.
Between the husband and myself.
Sir, are you married? 5,000. Dismiss with cost of rupees 5,000. You happy with that?
Or he is a destitute lady, my lord.
I think you should be happy with that 5,000 cost. Next, call the next matter.
Destitute lady, my lord, kindly consider the cost.
Cost baad diye do. Yes, call the next matter.
Grateful.
You want to set up a defense case in the Order 7, Rule 11?
Order.
The other judge recorded that.
My lord, in this matter, my lord, by mistake, I have left the brief at my residence, my lord.
Since an adjournment has been sought for, let this matter stand. These matters are no, sir. Monthly still come, sir. April.
No, my lord, kindly, my lord, it's folded and my lord, there is some.
Sir, I am helpless, sir. Sir, difficulty is I am helpless. Even if I place it in the next monthly list, it will appear at the bottom of the list. At the bottom of the list. So it will not be taken up another 10 months.
No, my lord, kindly, my lord, my lord.
Sir, people are waiting.
And my lord, I am.
Proceed, now. Take my brief and proceed.
My lord, kindly, my lord.
Take my brief and proceed.
Not really today, my lord.
So sorry, sir.
Kindly, my lord.
Matter filed in April. Sorry, sir. Yes, call the next matter. Yes. Yes. Sorry, sir. Please don't embarrass this court, sir. No, sir. No points. Yes.
This is the matter where, Milord, I appear on behalf of the petitioner stroke defendant. The petitioner stroke defendants. Now, Milord, there was a caveat. I have served a caveat. I have served a copy of the petition. I have served.
Affidavit of service?
Yes. Milord, this is the. Now, Milord, the matter, so far the present matter is concerned.
Affidavit of service?
Milord, in course of the day, permit me to file before my.
Me, Mr. Bhattacharya. Yes.
Milord, suit for declaration and Milord, consequential relief. Milord, in a very.
For the defendant.
I appear on behalf of the petitioner stroke defendants. Yes.
Yes.
Now.
What are you challenging?
Milord, I am challenging the last order, but one funny thing has appeared before my lords. That I should show. Only.
No, 10th April 2023.
Yes.
Order
Now,
passed under Order 39, Rule 1 and 2.
Milord, this is the order which was passed, which has been challenged. That is 10th of October 2023.
Order passed under Rule 1 and Order 39, Rule 1 and 2.
Yes.
Appealable order.
No, I am not on that. I am not. Otherwise, I would not have troubled my lord. Kindly come to one order. It starts from page 20 to 30.
No, I cannot permit you to challenge this order under any
I am
circumstance.
not. I am only praying for what will be the effect, or rather, what can be the particular recourse. I am not for a second. Milord,
Appeal has to be filed.
Milord, I know that, Milord, your lordships, kindly come to this order, Milord, which was passed.
Page,
Milord, it starts from, Milord, this is internal, Milord, just a second, Milord. Just a second.
Yes.
It starts from page 20.
Yes.
Now here,
So injunction application order.
Kindly, I appeal to my lords, Milord, for a second, Milord, kindly have the patience.
Yes.
Kindly see, Milord, the first paragraph. By filing the instant petition, the petitioners prayed for issuance of a temporary injunction restraining the defendants and their main agents not to go on to enter into the B schedule property, and for changing the nature and character of the B schedule property, and not to interfere in the peaceful possession and enjoyment of the petitioner's disposal. Now, in this suit, upon hearing the claims and counterclaims, kindly see what is the order passed. This is the order, my lords will be pleased to find the operative portion, page 29.
Yes.
The petition filed by the plaintiffs under Order 39, Rule 1 and 2, read with Section 151, is rejected on contest and disposed of accordingly.
Yes.
Then, my lord, as the temporary injunction has been disposed of, the petition filed by the plaintiffs, petitioners praying for extension is also hereby rejected. No, my lord,
First application was rejected.
Reject.
On the same point, second application was moved.
Now, then,
Yes.
my lord, yes. Then, my lord, I'm grateful
Abuse
to-
of process of court. I cannot help you.
My lord, abuse, absolutely correct. my lord.
Abuse of process of court.
Abuse of the, now, kindly see, my lord, that page, this is the last annexure which your lordship was.
That the original order is there.
Yes, this is, since this is the original order,
Yes.
I now draw to the my lord's kind attention about the last order. This is order number 37, dated 10/10/2023.
Yes.
Now, kindly see, my lord, I just draw to my lord's kind attention about this particular order. My lord, this is, my lord, the last page. Last page. That the petition filed by the plaintiff under Order 39, Rule 1 and 2, read with Section 151 of the CPC, is allowed on contest and disposed of accordingly.
Allowed. I've seen.
Allowed. Defendants
order, Mr. Bhattacharya.
and now the funny thing which I find, even if it has been allowed, fix on 5/1/2024 for ascertainment of the question under Order 10, Rule 1 of the CPC in order to determine. Lord, I am just.
No, Asha.
Yes, this is it. This is, my lord, I have got it.
Yes.
Yes, sir. Now, my lord, kindly see. Now they refer the matter under Order 10, Rule 1. Order 10, Rule 1 of the CPC in order to determine whether the dispute can be resolved as per Order 10, Rule 1A. I find Order 10, Rule 1A is a direction of the court to opt for any mode of alternative dispute resolution. After recording the admission and denials, the court shall direct the parties to the suit to opt either of the mode of the settlement outside the court as specified in subsection 1 of section 89. On the option of the parties, the court shall fix the date of appearance before such forum or authority as may be opted by the parties. Now, my lord, may I ask a question to myself? First of all,
Mr. Bhattacharya, appealable order, Mr. Bhattacharya.
No, I'm
Overcome
not on
that
that.
first. First, overcome that. Otherwise, I will not address anything on this.
If you're
Appealable order. Admittedly, Order 43, it is covered.
Yes.
Today, once it is covered under Order 43, this court will not entertain under 227.
Now, my lord, your lordship may kindly come to
Order 43, this is covered, Mr. Bhattacharya. How
Then
can I go? You take back the certified copy, you take your recourse. It's a bad order. Abuse of process.
That's
abuse of process.
and
But
I
how can
suffered
I
the
help you here?
consequences.
No, you take it back. I'll give you the leave to take back the certified
No,
copy.
had it been a case that this last portion is not there,
Still then, that I'll explain out. This is
that clarification, if it is not done, supposing, my lord, I take back this order.
You
then
give it,
what I have to
give it to me. I will explain the consequence of this fix for 5th January 2024. Because this will not interfere with the order. This is alternate dispute redressal mechanism is to be invoked. It will be invoked.
Dispute.
Now, if choice is yours, if you want to take it back, you take it back. I'll pass an order of court.
No, I as your lordship is indicating.
I'm not saying anything. It is
No,
entirely up to you, Mr. Bhattacharya.
No,
to
my
take
lord.
a conscious decision.
No, I say, my lord, under Order 43, as my lord is
Covered. Order 43,
covered.
go to Order 43.
Yes.
Absolutely covered. Even the second application, 151 order is not covered, Mr. Bhattacharya.
Yes.
This is not under 151. I've checked a first point.
Yes.
It was under 151, I would have invoked it. We're not covered. But order 43 to order 39, rule 1 and 2 directly covered under order 43. Kindly come to order 43, Mr. Bhattacharya.
That I have seen.
How can I interfere? First application rejected. Second application, abuse of process. There cannot be res judicata.
No, I am not saying.
No, but abuse of process of court. Yes, you are right. Umpteen judgments on this. Abuse of process of court. Identical on the self-same cause of action. Should not be allowed. Bad order. But I am handicapped here.
Your lordship is indicating that because of this particular
Yeah, how can I
petition,
go? Order
the court
43?
cannot assume any jurisdiction so
Yes.
far as this last order is concerned.
Absolutely.
That
First or second, both orders. First one under order 39, rule 1 and 2. Second order, order 39.
no, in the first order,
Or 39, rule 1 and 2.
yes,
Also.
order 39, rule 1 and 2, which my lords has seen. Now, my lord, there, if your lordship, my lord, kindly see.
Is rejected.
That is rejected.
So that also I cannot do anything because that is under order 49, 43.
If I have to avail of any remedies, I have to go before the competent court, that is the court in the learned
You
court.
take advantage of the pendency, go there, it will be easier for you. Take back the certified copy.
I'm right. But my lord, your lordships have to kindly, I appeal to my lords,
Yes.
kindly make an observation to the last
I
portion.
exercise jurisdiction. I cannot, if I exercise jurisdiction, then only. Otherwise, I
Lordship
will
is
not.
not exercising any jurisdiction, but your lordship always has an inherent power.
No, no. Once I exercise jurisdiction, I exercise
No,
it. Otherwise, it is not.
exercise of jurisdiction. Kindly see whether, my lord, the question of exercise of jurisdiction. Your lordship is not exercising your power.
It is under R. Order 43, 1 R.
Order 43?
1 R.
Yes, yes, yes.
Yes, Mr. Bhattacharya, take it back. You want to take back the certified copy?
Of course, otherwise I will be.
Take back, proceed.
I am
Be entitled to that for section 14.
I am extremely grateful, but my lord, your lordships may kindly consider.
I understood difficulty. My hands are tied, Mr. Bhattacharya. Once I exercising 227, I cannot. I cannot exercise this jurisdiction.
No, your lordship is
226 is different.
227, my lord, I had noticed, my lord. Yeah, I leave it to my lord's kind consideration. Lordship has a vast experience. Power of superintendence is being exercised under Article 227. While exercising the power of the superintendence, if the particular court comes to a conclusion that there was error of jurisdiction of passing an order, there, my lord, in my...
It is not perhaps an error of jurisdiction.
I say, my lord, it is an error. Why
it at what
I
best?
say, my lord, this is an error of jurisdiction. Why? Because first order, my lord, that has been passed very well. Now, second thing that the authorities, my lord, the petition filed by the petitioners under Order 39, Rule 1 and 2 is allowed on contest and disposed of. And then, my lord, that we are
Sir,
delegating the matter.
that is always, sir, that power is there.
That thing only I say nothing else.
No, sir, perhaps not, sir.
Because the Lordship is exercising the power of superintendence.
I am not inclined on this.
Superintendence. I am not saying that my lords is
In a better case, Mr. Bhattacharya. In a better case. In a better case.
no. That's a different.
Yeah. In a better.
Yeah.
Shut up.
Okay.
36.
পরে এসে ওটাকে সার্টিফাইড কপিটা নিয়ে
না একটা কপি দিলেই Yes, what are you challenging?
My lord, the order dated 5th.
Also, second.
I've not gone into merits, I've said. No, question of going into merits doesn't arise. I have not recorded a line on that. On the contrary, granted you leave, if so advised. If you are so advised. No, I do not know. He may or may not file. I do not know. So, leave is there.
By the first order, my lord, the date was fixed for further cross-examination of the PW1 that was closed. Although Hajira was filed, then on 14th of March, one application was filed for recalling of that order. That was also rejected. Being aggrieved, my lord.
Today is fixed for cross-examination PW1. Now it's 10/11/42.
Yes.
Face cross-examination.
Yes. It is now 11:42. PW1 is present on dock to face the cross-examination. Learned advocate for the defendant is found absent. My lord, any date may kindly be fixed for.
We were cross-examined already. It was on recall.
No, not recall. We made one application for recalling.
So it was on recall.
Original cross-examination is not over. Original cross-examination is not over. On document to face the cross-examination.
So the order sheet.
Then, my lord, I have to bring. Kindly.
The order is very clear on this subject.
No,
says today is fixed for cross-examination PW. Now at the due to face
absent on repeated call to cross-examine this witness, not on recall. Subsequently, we filed one application being that witness, we shall complete the cross-examination. Nothing more. Not that he was discharged. We made one application.
But over here, the only issue kindly takes up page 41.
On caveat.
On caveat.
I have sir.
Well, the issue over here is.
No. Cross-examination on that particular date, the advocate was not there.
This was the third occasion, my lord, where they have not cross-examined. That was your lordship will find the reason at page 41. 41 of the application.
Oh, on previous occasions also it was closed?
Yes, it had been adjourned on 3 occasions. Then it was actually, my lord,
what is the suit for?
It's for recovery of
declaration and recovery of possession by invoking section 2G. But, my lord, as per the recent judgment of the Apex Court, my father died in the year 1989.
That Justice Banerjee's judgment has been explained.
Yes. That judgment is now
Show me that judgment.
Yes.
Supreme Court judgment is this a Supreme Court judgment?
Yes. And it is also reported in ICC.
I've not read this.
Yes. Kindly come to the last. It cannot have any retrospective effect. Para 21. We are taking advantage of this.
And what can we? Sir, look, this is the interpretation of the law given by the court. So I am bound. You are bound. He is bound. You can say so many things, but at the end of the day, we are all bound by this judgment.
But
which paragraph? Place it.
Para 21.
Place it.
It is true that legislature can restrict heritability by amending or repealing the law, as the case might be. The division bench's finding in the impugned judgment is that since legislature can restrict the heritability, it has done precisely that in the 1997 Act by adding the words 5 years from the date of death of such tenant or from the date of coming into force of this Act, whichever is latter. Hence, as per the division bench of the Calcutta High Court, the death of S.K. Mitro in 1970 also stands covered under the new Act. In other words, the 1997 Act changes heritability rights retrospectively according to the division bench of the Calcutta High Court, although the actual date when eviction would happen is post the new Act, but it does have a retrospective application as well, in as much as it is applicable retrospectively to an earlier date 1970 in the present case, and had taken away a right of the appellants giving to them under the old statute. Statutory laws operate from the date of their enforcement prospectively. In case the legislature intends to make a law retrospective, then such an intention of the legislature must be shown clearly and unambiguously in the statute itself. The division bench's mere interpretation of a statutory provision will not make the law retrospective and take away the heritable rights of a tenant. And kindly come to the plaint, Lordship, kindly come to the plaint, sir. I have annexed at page 11.
No, you filed it when?
Yes, page 11.
You filed it when?
No, their plaint. Their plaint.
Yeah, it was instituted, my lord, in 2019.
2019, and
there was a prior suit.
not
which
only
perhaps
that,
was I do not.
prior suit was withdrawn. As per them, wrong
If it is
advice.
dismissed also, what happened?
Kindly come.
Cause of action survives?
Yes.
Fresh
But-
cause of action?
Kindly come to para 4, page 13.
No, I'm ascertaining that. So, suit for eviction, recovery of possession. Death of the original tenant when?
1984, according to them. Passed
According
away.
to you, when?
I do accept.
84.
My father died in 1984.
84. Then you are there residing with your
Yes,
father.
yes, according to them, admittedly. Then, and considering this, the earlier suit was filed under section 6(4) of the West Bengal Premises Tenancy Act. Subsequently, the new act came, the suit was withdrawn to invoke section 2G. Let them
Now,
do
2G,
this.
5 years from the date of institution, from the date of act.
1984 and
No, 1984, not
and
1984.
10 July 2001.
From 1997, 2G will have.
10 July 2001.
Okay, yes, sorry. When it came
10
first,
July 2001.
2001 to 5 years.
The
Means
suit was perfectly justified, but in view of the apex
when was the suit filed?
19.
2019.
So,
No. But in view of the apex court interpretation that if the tenant died, original tenant died prior to 10 July 2001, this act is not applicable, section 2G. It will be guided by.
No. That Supreme Court did not say.
Yes.
Anyway, and that is you.
Perhaps, my lord,
That's the point.
Why will it not necessary for me to interpret it? Why will I go into that question, sir?
Yes.
You proceed on the basis whatever you want to make the court.
Sir, I want to
Yes.
cross-examine. Kindly fix any date.
Now, my lord,
On cross-examine on what point?
On the point of.
Now it is a question of recall. You tell me on what point.
Kindly-
Oh, open cross-examination.
No. Not
is all
recall.
closed.
Not recall. I want to complete my cross-examination.
No, that I will not allow. You tell me on what point you want to cross-examine. I'll grant you liberty to cross-examine on only those points now. Enough you had. You tell me what points you want to cross-examine. I'll give you those time. I'll give finish.
Regarding heritability of this right as per the 1997
On
Act.
cross-examination will not help.
Not only that, under what circumstances, under whose advice the earlier suit was withdrawn, there are substantial points are involved. This is a factual aspect, and according to us, that they accepted me from 2001 to 2019. They accepted me as a tenant and received rent from me, even after withdrawal of the earlier suit. These are the points to be.
Is Order 18, Rule 17, whose application?
My application just for recalling of the witness to complete the cross-examination.
Now, this was rejected. This
This was
application is rejected.
yes,
So, that is the end of the matter.
Kindly fix any date.
No. If it is, that's why I wanted to know from you. Is it a recall or is it first time? You said first time.
No, first time. First time the application was under the nomenclature
No,
of
this is
Order
recall.
70. Recall means he has to be recalled. Otherwise, since the evidence has been closed.
Repeated
The
opportunity.
language is very different. Questions have to be identified. Why you want recall?
No,
What are
no.
the questions?
That is, if had it been a case that he was cross-examined at length and discharged.
So that is
Then-
different.
No, no,
Once
no.
you want a recall, you have to identify the questions.
Recall means just to complete my cross-examination, nothing more. Kindly see the prayer.
No, where is the previous order? It was closed. Where is the previous order?
That order is not here.
No, unless you show me the previous order.
I can place it. Do you have?
This order, my lord, is of 5th February, page 40, my lord.
Page 40.
Page 40.
Yes.
They were in cross-examination of the plaintiff's first witness.
It's present on doc.
No, I will not allow.
Kindly come. Learned advocate for the defendant is found absent on repeated call to cross-examine
So this
this
is the same thing. Page 40 and the judgment is the same one.
No.
Previous order.
Challenge two orders.
Two orders.
Where is the previous order?
Previous order before 5th February.
30th order, 30th you have challenged. Order number 3
Yes,
you have
yes,
challenged.
yes, And 31
Which is at page 40.
was when my recalling application was rejected to on repeated call to cross-examine this witness. So it can be concluded, kindly see the order number 30, that learned advocate for the defendant has nothing to cross-examine further. The word is further. Accordingly, the evidence of the PW1 is closed, treating that he is fully tested by cross-examination.
So he had been cross-examined
On
earlier also.
13-10, you took an adjournment.
Yes. But
And
the
had
court-
submitted that he will complete cross-examination next date.
Yes.
But he did not complete cross-examination.
Yes.
15 December.
Did not complete. It was done in
Further
part.
cross-examination on 5th February. Did not appear. No. Sorry, sir.
5th February. Kindly see, my lord. 5th February was the date fixed.
Yes, sir.
On that date, I was supposed to complete the cross-examination. That could not be done. In any case, the cross-examination of the PW1 was closed. So not that we want to recall for further cross-examination. I want to complete, kindly see the prayer. I want to complete the cross-examination, nothing more. A date may kindly be fixed.
No, sir, it's not that easy, sir. You will not go, you will not appear. The matter will not be heard. No,
explanation is there, my lord.
No, I'm not satisfied with the explanation.
No, kindly see that the explanation.
On the next date also you do not appear.
No, next
Yes.
day, only 5th February we have missed. Nothing more. Previous.
He says so. Defendant number 2, another court on 5th is not a good ground to justify his not appearance before this court.
Only 5th February, my lord, we have missed, and immediately thereafter we have filed the application on the earliest opportunity. How they will be prejudiced?
Matter has proceeded thereafter.
No. The learned court is lying vacant. Learned court is lying vacant. 11th bench is lying vacant.
Reasons why they have not pressed for this application despite it being filed in April 2020.
No. The matter is running in.
It's a dilatory ploy, my lord, over and over.
No.
It would be evident the conduct of the defendant in the suit.
We have
petitioner before your
intimated.
lordship.
We have intimated that the revisional application is pending. Not that. Immediately, my lord, we have filed the revisional application. Kindly see.
Limited to heritability.
Yes.
Only limited to heritability.
Yes. Kindly do this. Yes.
Only limited to heritability.
Yes. And withdrawal of the.
No, father, nothing. Sir. Those are all gone. If you have not asked. Only limited to heritability. That's it.
Okay.
And my lord also fixes
On
a
that
time.
one date.
Very great.
On any.
And I'll fix a time also.
Yes.
And it will be concluded within an hour, 1 hour cross-examination. It has to be, sir. Otherwise.
Yes.
Challenging the order numbers 30 and 30. You succeeded, sir.
And sir,
I've kept it here. I'll
Yes,
go
yes.
through it. Yes. None appears, no accommodation sought for. None appears, full stop. No accommodation has been sought for, full stop. Let this revisional application be dismissed for default. Next.
And also I am there for the professional, learned advocate Prantik Garai Thick.
They filed the on the prayer of the learned advocate. April. Now go out of the list. Go out. Madam, I'm writing go out of the list. I mean, regard that, let the matter go out of the list. Mistake. So go out. None appears. Same. None appears in support of the revisional application. No accommodation has been sought for. Full stop. So the full stop. None appears in support of the present writ application. Present revisional application. Full stop. No accommodation has been sought for. Full stop. In view thereof, let this matter be dismissed for default. Yes, next.
I am appealing for the defendant petitioner. The plaintiff opposite party filed a suit for declaration and permanent injunction. In connection of that suit, Order 39 Rule 1-2 application was filed before the Junior Division Asansol Lordship. That was rejected. Thereafter, they misappeal. Misappeal filed by them and ad interim injunction was given, Lordship. I am not on that. What is, Lordship? The date which is given beyond the statute. Order 39 Rule 3A has not yet been followed up. The order which I challenge, kindly come to the ordering portion, Lordship. That is the 2nd February 2024. Also, I annex the Lordship type copy.
Where is the order? Where is the order?
Order, kindly come to the. I have annexed this, Lordship. Kindly come to the.
Where is the original order? Which order? Which order?
Order date 2nd February 2024. The date which is given, that is the beyond the statute. Order 39 Rule 3 has not yet been followed up. Lordship, the date more than 30 days. My prayer.
Which order are you challenging?
That this order, Lordship.
Which order?
2nd February 2024. This is a handwritten order, Lordship.
Order number, order number.
Order number is 7, most probably 7, Lordship.
Place the order. Place the order.
7.
Place the order. Oh, Baba.
Lordship, regular PO has transferred plenty files, petitions, praying for injunction on interim prayer is allowed till next date. Defendant number.
What is what is so wrong in this order?
Lordship, order 39, rule 3A state that within the stipulated
And
time.
when was the injunction granted? By this order, no injunction was granted.
No, that is, he has allowed extended. That was extended.
And extension will not have any point in serving fresh copy.
I have not done that.
When was the order granted?
Kindly come to the.
Yes, order was granted on 20th September 2023.
Yes. That is the ad interim order or injunction was allowed, Lordship.
Yes, on the next date, he has complied with order 39, rule 3AB.
Yeah.
What more do you want?
I want the direction for the disposal of the misappeal within certain stipulated time, Lordship. Otherwise, the suit will not be proceeded, Lordship. Because of this, only one direction is to be given. No accommodation is to be allowed. Either of the parties, direction is to be given by the Lordship to dispose of the misappeal within certain stipulated time.
Huh. Is the court lying vacant?
At this moment, I am not in a position to say.
Tomorrow to be mentioned, ascertain and come back.
Lordship, tomorrow, because one electricity matter is there, I will have to go there, Lordship, because otherwise the
Tuesday, to be mentioned Tuesday.
Tuesday.
Yes.
Yes.
The petitioner is directed.
That's why it was rejected. Due to change of nomenclature, I got lost.
Why?
Kindly see the order.
Yes.
The second page, my lord. The specific cause, defense.
For what reason did you file local inspection? You are the defendant.
I am the defendant, my lord. Actually, this is Sali land. I have changed already the land, character of the land with the permission of the BLRO. All these things is required.
You have got an order under 44C.
Yes. Everything is complied. But in spite, in order to locate the location of the land, actually it is situated in the high road. Whether it is high road or not, that is required to be examined.
Why? What does your porcha say?
Porcha say? Porcha no, it is adjoining to the high road, my lord. That's why
your porcha will show a regular, there is a Moja map, sir.
Moja, there is a road. There is a road.
Then? Why do you want this local inspection? From the Moja map, you can ascertain where is this located. What is the suit for?
Suit for partition, man. Suit for partition. Since 2021, 2011, the suit is continuing.
Preliminary decree has been passed.
Preliminary decree had not yet been passed.
Shares are not
Only
admitted.
evidence stage is now.
Shares are not admitted.
No. Only evidence was closed on the part of the plaintiff is closed.
You have filed an application under Order 39, Rule 7.
Yes. Instead of
Order 26.
That's my fault, man.
Having heard the learned advocate appearing for the petitioner, can you serve tomorrow?
Allow me 10 days. 10 days time, man.
I'm not sure it will take 10 days. It will be appearing
No,
by
man.
Monday.
Sirampur court.
You serve today.
Today,
Serve,
I'm
serve
sending today.
Send it
Later,
today.
later date, please.
Say January monthly list, it will appear.
I am sending it today.
January month is Monday. Send it today itself.
I am sending it.
Yes. It will appear in the January monthly list. With a covering letter, send it. If they do not appear, I will allow your application.
Grateful, my lord.
My lord, I am for the petitioner. I have received instructions, your lordship, to withdraw this application as not pressed.
Ms. Lala, learned advocate representing the petitioner on instruction would submit that
Your lordship, my advocate on record is present.
He
is present.
Ms. Lala, learned advocate representing Give your appearance. Your appearance is noted in the order. Give your appearance now.
Yes. 63, my lord, I am appearing for the petitioner. My lord, the plaintiff filed a suit for declaration and injunction. I am the defendant. I have challenged the order. Kindly see the last order, my lord. 30th November 2023. My lord, in the suit, my lord, previous learned advocate who appeared and filed also written statement, he died. Thereafter, my lord, I was engaged in the lower court to conduct this case. What
are you seeking?
My lord, expertly, I'm reading this order, my lord. Order number 29, dated 30th November 2023. The date is fixed for production of the power of attorney by the defendants and also for appearance of the parties. Hajira is filed.
Matter is fixed for ex parte hearing.
Ex parte, yes, my lord.
Yes.
Since, my lord, I was not at Calcutta, my lord, I could not appear, and none appears for the defendant. That already judge noted. And
Appealable. Go and prefer an appeal in that case. Why will I interfere in the revision? Why will I interfere in the revision?
Interim stage. They filed an application under order 11, rule 20, rule 14 for production of certain document.
Yes.
Then, my lord, there was direction to serve a copy upon me, but no copy was served. In the meantime, the matter was heard, and that application was allowed. Then, my lord, I filed an application for recalling of that order, whereby that application filed by the plaintiff under order 11, rule 24 was allowed. That, my lord, application was fixed for hearing. Then, my lord, since, my lord, I could not be present on that date, that application was rejected and matter was fixed for ex parte hearing. That I have, my lord, challenge here for sitting aside, praying for sitting aside. That interim stage, my lord, I'm reading the next portion. An application has been filed by defendant number 1 praying for recall of the order dated 12 April 2023. Copy, sir. The order dated 12 April 23 has not been complied with by the defendant. When by this my lord, order 12 April 23, the learned judge directed to serve the copy of the to produce the copy of the power of attorney, which was not with me. However, let the petition dated 30th 11/23 be fixed for hearing. Then, my lord, the last order is, my lord, 15/12/2023.
Yes.
By this order, my lord, the matter was been fixed for ex parte hearing. My lord, I am reading this one.
Yes.
Order 15th December 23. A petition dated 30th 11/2023 is fixed for hearing. Well, by that petition, my lord, I prayed to recall that order. Then, my lord, none is present for the defendant. Defendant is absent without steps. Hajira is filed by the plaintiff. Heard the learned advocate for the plaintiff. For non-appearance, the petition dated 30th 11/2023 filed by the defendant is rejected. Then, my lord, it appears that the order dated 12/4/2023 has not been complied with by the defendant. In that, my lord, order, there was direction to produce the original copy of the power of attorney. That I have, my lord, prayed for recall.
Order 9, rule 9.
No, my lord. Order 11, rule 14. That I have also annexed.
No, this is dismissed. Order 9, rule 9.
No, my lord. Order not order 9, rule 9.
You did not appear on that date.
That was an interim application.
Your application, you did not appear.
Yes, my lord.
How can I that appealable order?
That application was fixed, my lord. I could not appear.
That is an appealable order.
No, my lord. Can you see, my lord?
Why, what, no, sir?
Non-appearance, the matter now should be fixed for ex parte hearing.
So, what are you seeking recall?
Recall by this order, my lord.
How can I? You have preferred an appeal from this order. You prefer an appeal from this order. Why will I recall it? Order 43, come to order 43, order 9, rule 9.
There is no application under order rule 9, order 9, rule 9. That was an application for recalling of the order. Can you see my
not application, sir. Please understand. An order under order 9, rule 9. An order. Not application. It's an order.
No, my lord. There is nothing of that sort, my lord. Order 9, rule 9 is not there. My lord, kindly, my lord, come to our my lord application. Annexure P5, page 51. Annexure, my lord, P5, page 51.
And you are agreed by 15 December 2023 order?
15 December, yes, my lord.
Why will I recall this?
Last order.
Why will I allow this?
My lord,
who are you? Defendant number 3?
I am defendant, no defendant.
Which defendant?
Defendant, one defendant number 1 and then pro forma defendant. 2 are there. I am for defendant. My lord, that a petition dated 30th 11/23 was fixed for hearing. Since I was not there, my petition was rejected and matter has been fixed for.
Where is the order dated 12th April 2023?
It have order dated 12. Yes, madam. 12 4. That is my lord. 12/4/23. Date is fixed for passing order in respect of a petition under order 11, order 14 of the civil filed by the plaintiff. It appears that the prayer for production of the alleged original power of attorney is reasonable, and as such, the said power of attorney alleged to have been executed in favor of Om Prakash Pandey should be produced for proper adjudication of the suit. Hence, upon consideration of the facts and circumstances of the case, the said petition dated 1st August 2022 made by the plaintiff is allowed. Fixed 8th August 2023 for production of the power of attorney by the defendant and for appearance of the parties. So by that order, the learned judge directed to produce the power of attorney.
Correct.
Then, my lord, I filed an application. My lord, kindly see my application, page 51.
Yes.
My lord, an application for recall that order.
Why? Why?
Since, my lord, that was past expertise, there was direction.
Forget it. You will not produce your power of attorney?
No, my lord. That was part expertise. Since here I have stated, no power of attorney is lying with me. There was direction to serve the copy of the application filed by the plaintiff under order 11, rule 14 upon me. No copy has been served. I did not get opportunity to controvert the allegations. Then, my lord, since, my lord, I was not present.
Where is the application under order 11, rule 14?
Yes, my lord. That also I have it. Yes, page 3, man.
Dictation and drawing.
Annexure page 3, page 37. Yes, page 3, my lord, page 35.
This was allowed. Yeah, you are claiming interest on the basis of the power of attorney.
They are claiming, my lord.
You are claiming also.
I say, my lord, no original power.
Are
of
you
attorney
claiming
lying-
interest on the basis of power of attorney also?
Yes, yes.
And you will not produce the power of attorney?
Since that is not lying with me.
I will record that the power of attorney is not with you. And you cannot derive any benefit therefrom.
My lord, that
I'll record that.
I wanted to file an objection
Please
against that
understand,
application.
the power of attorney is not with you. Power of attorney executed by whom?
That he died. Almost some Om Prakash Pandey. He is not the party here.
He has died.
Yes, my lord.
So the power of attorney is
They are his sons and daughters. My lord.
power of attorney is useless. The power of attorney is useless. I will record that since the power.
On the basis of that power of attorney, a lease deed was executed.
But he will
Lease
not
deed was
produce the
executed.
power of attorney.
But Xerox copy is lying with the plaintiff.
No, you
They have
produce the
stated.
original. You produce the original of the power of
That,
attorney.
my lord, that I wanted to state in before the learned lord trial court.
Where is your application? It is not lying with you. Where is your application? I will matter will come to an end immediately. And all the lease deeds will go. Your basis will go.
Kindly come to my annexure page P5, recalling application. Page my lord 51. My recalling application.
Where have you said that the power of attorney is not lying with you?
Yes, my lord. Paragraph
Which paragraph?
I am relevant paragraphs I am reading. Paragraph 3. The defendant one myself did not get the opportunity to controvert the allegations made in the said application. However, the learned court, after hearing the plaintiff, was pleased to pass an order directing the defendant number 1 to produce the original power of attorney. That the defendant number 1 most respectfully states that he does not possess the original power of attorney. Paragraph 4. As wrongfully stated in the said application filed by the plaintiff, since the defendant number one did not get the opportunity to file the written objection against the state application, controverting the statements or allegations made in different paragraphs of the state application, he was not in a position to place the real facts and circumstances before the learned court for proper adjudication of the matter.
The matter will be over, sir, the moment I record all this. Because your basis of your claim is the power of attorney. On the strength of the power of attorney, the lease deed was executed. I will record that you are not in a position to disclose this. And the trial will proceed on the basis by treating you do not have custody of this document. And this document does not exist at all. Will be permitted to
There
get
is
filed.
existence. They have
If this unless on the strength of the power of attorney, the lease deed was executed.
Yes, ma'am.
If there is no power of attorney, the lease deed will fail.
They have stated
Whatever
in
is the consequence, what will happen, sir?
My lord, they have stated in the plaint. They have stated in the plaint that there is a xerox copy of the power of attorney with them.
Matter will go, sir, for a toss. You make up your mind what you want.
Well, then, my lord, kindly adjourn this. I will take further instruction from the client.
Today, now. I'll reject your application otherwise. If you are not ready and willing to produce it, I'll reject your application. Over phone, ask him that he is ready and willing to produce it or not.
Well, then let that be decided by the lower court, my lord. I have only, my lord, today prayed for recalling that. Let the lower court hard out this matter, my lord. After hearing me and my objection also, I will get the opportunity.
In your
to file
written
the
statement,
objection.
where have you said, sir, these matters should come to an end. Earlier the better. Which paragraph in your written statement treated the power of attorney?
Xerox copy, yes, my lord.
No, yes.
In the plaint, they have stated.
Ramodin Pandey. According to you, Ramodin Pandey executed the power of attorney. The plaintiffs number 1, 2, and 3.
No, their father. Ramodin Pandey.
Yes. Come to page 29. I will record that if you are unable to produce, consequences follow. Everything you are claiming on the basis of the power of attorney, you will not produce it. It cannot continue.
That is lying with whom? That is lying with whom?
Where have you said in the written statement it is lying with them? Where have you stated it is lying with them?
There was direction, my lord, to serve the copy of the application filed by the plaintiff under order.
Anything else you want to submit?
No copy was served upon me. Then, my lord, I took a copy from the record. But before filing any written objection, that was heard. Well, let that be decided by the lower court after giving me an opportunity.
Not necessary. Notarized. Power of attorney is notarized. Paragraph 18. I will record that even unable to produce, the court will proceed on this basis, finish of the suit. By following the consequences as provided for in Yes, sir.
But at this stage, my lord, I'm praying, my lord, to set aside their order and give me.
No, I will not, sir. Anything else you want, sir? Anything else?
Let that be, my lord. Then my application, my lord, for recalling be heard out, my lord, by the.
Everything has been heard out, not complied with.
But that order was passed, my lord, expertise. When no copy of the said application was served upon me. Thereafter, my lord, I filed the application for recalling. And since, my lord, the defendant could not appear, that was rejected. But that was fixed for hearing. That application was dated 30th November 2023. That application was fixed for hearing.
You cannot also explain to me before this court also.
Make it not today, my lord. I will take further instruction from my client. But there is existence of power of attorney since when in the plaint they have stated they have a Xerox copy of the power of attorney. In the plaint they have stated.
I'll ask the court to finish off the matter. Anything else, sir, you want to add?
This is, my lord, what is in my. I am praying, my lord, on adjournment for that. For taking instruction on that issue, my lord, from my client.
You take instructions from your client, whatever you want. Order 11, Rule 14, application they had filed.
Yes, order 11, Rule 14.
Yes.
But that copy has not served upon me. There was a direction. Kindly see the order.
Not necessary.
Kindly see the order. There was a direction to serve a copy. Copy not served, my lord. Order 23. Order number 23. Application under Order 11, Rule 14 of CPC has been filed on behalf of the plaintiff. Copy not served. So without serving any copy to me, my lord, the matter was heard. I did not get any opportunity to controvert the allegations, my lord, to place my case.
I'll provide that order 21 will follow. Rule 21 will follow. Order 11, Rule 21 will follow. That the court has done. That the court has done. Fixed for expert hearing.
Expert hearing, my lord, I am again, my lord, harping on the last order. Order dated 15th December 2023.
Yes.
For non-appearance, the petition dated 30th 11 2023 filed by the defendant is rejected. So, my lord, this petition dated 30th 11 2023 was for recalling of that order. Then, my lord, it appears
challenging the order dated Disposed of.
I have to come again. If that is not allowed, then I have to.
And what can I do, sir? Insofar as your main thrust is non-production of the power of attorney, consequence will follow.
That is lying with me or
Finished. Matter ends. The moment you do not show it, everything is over for your case.
I am saying that is lying with the.
No, you are never said so in the written statement. একটা line জুড়ে দাও তলায়। Although the learned counsel appearing in support of the present revisional application had attempted to make out a case from the bar that the power of attorney was lying with the plaintiff, the foundation of such statement is neither found in the written statement nor in the application for recall filed by the petitioner. Yes, madam.
Original side number 1.
Oh, original side. Original side. লিস্ট কেন শেষ হবে? অনেক আছে তো। তারপরে মান্থলি লিস্ট হবে মোশন। হ্যাঁ। লিখে দাও মান্থলি। হ্যাপি নিউ ইয়ার। লিখে দাও।
For I placed my case, Happy New Year, my lord. I know, no, other side is not required, my lord. It's only for allowing the praise for conducting the sale of the assets of the company, which is pending tomorrow, Monday. Three.
Lordship, time for the petition.
My lord, item 2, has my lord given a note today for item 2?
Yes, madam. Monday. Come back on Monday.
Okay, my lord. Grateful, my lord.